Yes.
My lord, this anticipatory bail matter was supposed to be listed yesterday. It is not listed as yet.
Will all be listed in due time.
No.
Don't worry. These are vacation matters, right?
No, my lord, regular bench matter.
Regular bench matter. Okay.
Not vacation bench matter.
Hiren, এই ডিপার্টমেন্টের লোককে ডাকো তো। কেন
Regular bench matters, bail application.
bail all mentioning, please give the slips, tomorrow it will appear.
Well, mine is a mine is a bail application, my lord, which is in the nature of an appeal because it is being investigated by the NIA, my lord. That may kindly be added, my lord, to the list.
But they go to the other bench. It's not our jurisdiction.
But now, my lord, your lordships have the jurisdiction, my lord.
As of now, we have
Lordships.
yes, that will
Lordships.
all bail
And
applications and appeal.
lordships. I'm deeply obliged. I'm deeply.
Yes.
Bail in connection with appeal. Bail in connection with
Later
appeal.
on, stay in jail. Convicted man. Connection. Yes.
CRADB 39 of 2024.
For what?
Suspension of death sentence.
We are not interested.
Under anticipatory bail, this
Suspension of death sentence.
No, not death sentence. Term of 10 years. He had custody for 8.5 years.
Then wait for 1.5 years.
Another one is CRADB 684 of 2014. Both are jail custody
We will
for
cons-
more than 15 years.
We will consider mention after 16th.
After 60.
After 16th.
Grateful mind.
Lordship, modification of anticipatory bail.
Bail.
Anticipatory bail.
under anticipatory bail, it was made returnable today. My interim protection is expiring today, my lord. Let it be listed.
My lord, relaxation of
I'm
condition of bail, your lordship.
আরে ডিপার্টমেন্ট থেকে যা দিয়েছে না, ডিপার্টমেন্টে যা আছে এখানে আসবে। ওকে ডাকো তো।
Lordship may be permitted to mention one matter for relaxation of condition of bail, your lordship.
Bail we are not entertained.
My lord, mentioning for inclusion of an appeal matter.
After 16.
My lord, this is bail in connection with appeal. But my lord, appellant terminally ill and both kidney are damaged.
We will consider after 16.
Kindly
After 16. Call the list. এটা আগে বলতো তাহলে তুমি নাকি শুক্রবার আসবে না? না মানে তুমি কনফিডেন্টলি না
Your time applying for
Milord, I appear on behalf of the state.
but today speaks for the report of the authentication test. But I have filed an application regarding juvenility of the applicant.
I think the report has been submitted by the Registrar General, Milord, must be in seal cover. The last hour.
খুলে এটা, কি বলে? When offense was committed?
The offense is committed on 23rd of September 2017. And you know, I have annexed a school leaving certificate.
23rd?
23rd of September 2017.
Hey.
22nd of September 2017 is the date of FIR.
Saying 25 to 35 years.
Twenty-five to 35 years. 25 to 35 years. Twenty-five to 35 years যদি হয়
তো
তাহলে তোর
2017.
2017
16 years.
2017
17 years.
25 to 35 years.
16 years, not according to the date of incident.
16 plus
16 plus.
How 16 plus? 17.
17.
17. Today is 24. 7. So 25 minus 7. 25 minus 7 is 18. Where is 16?
22nd of September. 25 years.
আর 2017 সাল তো
17. Today is 24.
24
So 17 and 24 is 4 and 3, 7. So 25 minus 7 is 18. So these are above 18. Report is placed on record. Ossification report is placed on record. The report shows petitioner is aged between 25 to 35 years on 25/4/2024. Incident occurred in
22nd of September 2017.
September 2017. A determination of age of an adult person, determination of age of an adult person
তাহলে ঠিকই আছে বয়সটা ঠিকই আছে
is
18 years old.
approximate in view of the range given in the report we are of the opinion that now, in view of the range given by in the report, even the minimum range, that is 25 years, would bring the petition, would make the petitioner aged around 18 years on the about 18 years on the date of occurrence. Under such circumstances, we are of the opinion the ossification report does not give an impression that the petitioner was minor at the time of occurrence. Application is accordingly disposed of. Appeal is ready for hearing.
Yes, madam.
Let the matter be placed for hearing.
আমরা কি apply- আরে আম-
না, ওইটা 18 ইয়ার্স হচ্ছিল 5 3 8 হচ্ছে, আরে 7 বললো 8 হচ্ছে, 8 হচ্ছে 25 5 would be around, even if the minimum 17 years of the date of occurrence, the- under such circumstances, we are unable to accept that the petitioner was a minor at the time of occurrence. Now, a prudent course may be to take the midpoint of the range, that is 25 to 35, that is 30 years, which would clearly show that the petitioner was an adult at the time of occurrence. Next,
Wait, please, your lordship, I have
লোককে মেনশন করতে হচ্ছে কেন অ্যান্টিসিপেটরি বেল? Yes, next matter.
But I appear for the petitioner. Item number
I'm for the
item number 3, my lord. I appear for the petitioner. One of the allegations involved are under section 406.
I need some time to bring
Both-
case diary. This is a old matter. I have written the case diary.
All right. Day after tomorrow.
Yes.
My lord, item number 4 has been, my lord, erroneously, my lord, tagged with item number 3, my lord. Item number 4 is arising out of a separate FIR.
All right. 4B detect. Yes, call 4.
I'm for the de facto complaint.
My lord, I appear for the petitioner, my lord.
You are for petition.
My lord,
Day after two.
Bring
petitioner.
tomorrow. Day after tomorrow it will appear.
Press.
There is 5 also. I don't know whether
5 also.
Yes.
now follow. 4, 3, 4 আলাদা করে দাও।
Yes, next matter.
3, 4 একসাথে।
But 3 and 5 are arising out of same FIR. 3 and 5.
Then 4.
4 is out of a different FIR. 3 and 5 are arising out of same FIR.
Same
5
FIR.
is 4 is, my lord, arising
But you are
out
appearing.
of
You are representing the petitioner in 4
the
also.
petitioners in all the, yes,
All the 3.
in
All
all
right.
the 3 matters.
Item 3 and 5 shall be heard analogously. 4 be detached. All the matters shall appear day after tomorrow.
পিএস কেস নাম্বার গুলো দেখে নে। Three আর 4, 3 আর 5.
Seven melodam for the petitioner not present.
Not pressed. Next.
De facto complaint has been notified.
FIR lodged after 20 days, Lordship. And Lordship petitioner age 18 years, de facto
164.
complainant age 29 years. She is a married lady, Lordship. And she have also son also, Lordship.
Let us see the 164. Petitioner contends that the de facto complainant is a married lady and has falsely
At the time the offense was committed, she was carrying. It a service plan.
Similar, yet for the state.
She is the last order. Though this is a case of allegation of kidnapping, but she was not kidnapped. She willfully came to the High Court, affirmed the affidavit for the petitioner, subsequently the direction was passed. Now, my lord, the victim is ready to give her 162. But now she is not, my lord, willing to go that area, my lord, because now she is apprehending that her husband is the police constable. Now, if she wants, my lord, will go that area, then my lord, she may be detained, my lord, because she kindly give some protection or her statement will be recorded from other.
Malad, the protection we have already offered, Malad. Will kindly see in the report also there is a reflection that I also assure that learned advocate the necessary police assistance will be provided from the end of Nanur PS. So there is no bar.
All right. Officer in charge, so and so police station shall ensure police escort for police escort to the victim lady to and from the magisterial court for recording her statement under 183 PNSS.
But once she gets in touch with the officer, because she's not being accessible most
Officer
of the
in charge shall approach the victim lady and extend necessary assistance. Full stop. Matter will appear 1 week hence. 2 weeks. ये करता है देखता है क्या
My lord, I appear for WBSC DCL. Lordship asked me to take instructions in this matter, my lord. My lord, the final assessment is 79,933. I have taken instruction.
Deposit 50% of petitioner undertakes to deposit a sum of deposit 50% of the bill for against the bill for unmetered consumption, that is rupees so and so. Within 7 days,
15 days.
within 15 days, matter will appear on 3 weeks since.
Grateful. Great. এটা half.
But still, they have not said that he is very all of them this way.
Out of 7, 5.
Quite well. They are all he's from yes.
My lord, I'm for the petitioner. My lord, item number 12, my lord. My lord, there is 302, my lord, liberty to correct the cost item.
Within 10 months of marriage, while she was in hospital, this is
my lord,
the victim statement.
my lord, there is 302, liberty to correct the cost title, my lord.
304B.
No,
302 also.
there, 302. My lord, husband, the allegation in the FIR, my lord, that husband administered the toilet, husband is on bail. 2 other co-accused has been granted anticipatory bail by this honorable court. My lord, I am the mother-in-law.
Well, this is the statement of the victim while she was in hospital. The petitioner caught hold of her and the husband poured poison on her mouth. This is the statement. She died subsequently.
Petitioner is the mother-in-law of the victim lady. It is contended other in-laws have been granted anticipatory bail. Husband is on regular bail. She prays for anticipatory bail. Learned lawyer for the state opposes the bail prayer. The prayer, we have considered the materials on record. Statement. Of the victim recorded during this victim statement shows that petitioner had held her when her husband poured poison in her mouth. In view of the contributory role played by the petitioner in the murder, we are of the opinion she does not stand on the same footing with other in-laws who have been granted anticipatory bail. Accordingly, we are not inclined to grant anticipatory.
My lord, liberty to correct the cost title, 302.
13, my lord, I beg to appear for the petitioner. My lord, the offence relates to 307 and several other sections of the Indian Penal Code. My lord, the allegation is that the parties, the petitioner as well as the de facto complainant and her relations, are the, my lord, were fighting with each other with regard to the ancestral property. Suit is pending amongst them, my lord. We got an injunction order. My lord, thereafter they violated the injunction order. We filed a, my lord, violations case. Thereafter, the instant case. We also lodged a complaint on the same day. Our complaint culminated into general diary. Their complaint culminated into the instant case, man.
Page 15, man.
Statement.
Statement, my lord, injured statement, page 9.
তোমার কদিন ছুটি? Poor. You are Sobuj.
Yes, my lord.
We have considered the petitioner content there.
Then I am not
is a
present.
not present. Surrender. Next.
My lord, 14, I also appear for the petitioner, my lord, I will not press that.
Which one?
14.
14. Why?
14, my lord, I get instruction to not press that application.
Say different case, na?
Correct. Okay.
The other accused we would have given and
His brother, two brother.
this one?
No, earlier one.
Huh.
Two brother, one there
but
is no
Sobuj
road.
had it. Yes, next matter.
Grateful.
Yes. This one.
Petitioner. Your old husband. I have been charge sheeted.
Twice she was assaulted, that medical supported with a medical. Twice in the year 2021 she was assaulted. And
Very good. We have
2024
considered the
also she was
materials on record. Allegations of assault, medical report.
My medical report is there of 2021 as well as
21 will not do.
2024 is also there.
Let us see the 24. Medical reports do not show that the injuries are life-threatening. Under such circumstances, we are of the opinion custodial interrogation in charge sheet file. Investigation is complete. Under such circumstances, we are inclined to grant answer.
I'm grateful on it.
Different DS. Yes, Galaxy. Wait and see now. Yes.
May I please your lordship, my lord? My lord, on the last 16. Lord, on the last occasion, my lord, I have mentioned.
Cheating.
Lordship.
Lord,
There are
I'm
transaction
appearing for the
details, Your Lordship.
petitioner.
I have handed over the case ID, transactional details. He has received money from from the Pandal sponsors, and there are antecedents as well. He has done the similar act with similar other.
Why did he took money?
Your lordship, I am appearing for the de facto. Well, I am appearing for the petitioner, my lord. My lord, on the last occasion, my lord, I have mentioned this matter before the honorable division bench, my lord, presided over vice lordship, my lord, Joyce and Gupta, my lord. But there, my lord, I have mentioned regarding the extreme high-handedness, my lord, when I went there to comply the section 35(3), my lord. The lordship was pleased to direct me to file a supplementary affidavit, my lord.
There is no compliance of 35+3, Your Lordship.
Yes, well, I went there to comply, my
been
lord. Lordship may kindly come to paragraph 3 of my supplementary affidavit, my lord. My lord, when I went there to comply, my lord, the police told me to stay there till 2. My lord, suddenly I fell ill, my lord. I came home, my lord. I called him. I personally called him, my lord. My lord, he half.
Have you taken?
Around more than 7 lakhs.
My lord,
have we asked you anything? How much money?
The contract was settled within 10,75,000. I have duly complied with the terms of the agreement. They have not paid the money. Totally civil dispute. They are trying to give this a clock of criminal proceeding. Totally civil dispute nature.
Yes, tell us.
The fact is that the de facto complainant is the general secretary of a local club. Like every year, they try to organize the Durga Puja, and for that reason, the de facto complainant was given responsibility for making pandal, and the de facto complainant contacted with the petitioner and agreement was made on 11,70,000. Within that 7,20,000 was paid. Despite that, the petitioner did not came and the pandal did not make. For that reason, this club could not organize Durga Puja properly.
No,
and they have lost the complaint on 8th. And that is
one
that.
second. You are the club.
Yes, general secretary of the club.
You are the general secretary. So you gave them 7 lakhs for constructing a pandal. It was not constructed.
No, your lordship.
Then
Well, it was constructed, Milord.
No.
My labours have duly complied with the terms of the agreement. Milord. They have completed the pandal, Milord, everything. That I am supposed to get money, Milord. Instead of that, Milord, to settle scores, Milord, they have initiated this case.
How do you say it was constructed?
Lordship, there are antecedents also. Similar
One second.
When Milord, puja was duly performed over there, Milord.
Show us the pictures of puja being performed. Show us pictures of puja being performed.
You know, I'm praying for 1 day accommodation, Milord. In the meantime, Milord, I shall place that. Milord.
Please that.
Your lordship, after when they did.
Milord, I want to.
We are not concerned. If the puja was performed, there was a pandal of sort, there is part performance.
Sir, your lordship, the pandal.
Milord, I want.
All right, we have.
Milord, I want to mention one. Milord, I want to mention one more thing, Milord.
The dispute is civil in nature, and he had constructed the pandal. There are outstanding dues payable by the de facto complainant. He pays for anticipatory bail. Learned lawyer for de facto complainant contends that the petitioner failed and neglected to construct a puja pandal, although money had been handed over to him. Learned lawyer for de facto complainant submit that petitioner had failed and neglected to had committed similar acts in the past. We have considered the materials on record. Allegations at its height disclose breach of contractual obligations, while de facto complainant contends that petitioner did not comply with, did not perform, did not construct the pandal, but misappropriated the advance. It is the petitioner's contention that the pandal had been constructed and puja duly performed. In light of the aforesaid circumstances, we are of the opinion custodial interrogation for progress of investigation is not necessary, and petitioner may be enlarged on anticipatory bail subject to conditions. 10,000 tuitions meet investigating officer once in a week.
I'm extremely grateful. Lordship, I just want to mention one thing, Lordship.
Next.
See, I just want to mention one thing. On the last occasion, Milord, Justice Sengupta was pleased to direct the personal attendance of the IO, Milord. He held me filthy languages over phone call, Milord.
You have got anticipatory bail, go.
I'm great.
Now, my lord, one Chittoranjan. Now, my lord, one Chittoranjan was the owner of the properties. Now, my lord, Chittoranjan died in November 99. He left behind his wife Saraswati, de facto complainant, one daughter Binapani, who was also known as Chitra, and one son Ramesh. Now, my lord, in 2005, my lord, Binapani alias Chitra, my lord, transferred some of her portions to her elder brother Ramesh. Now, my lord, the remaining portion, my lord, she executed a deed. Now, my lord, in favor of the petitioner number 4. Now, my lord, in that deed, my lord, she signed as Chitra. Now, if your lordship, my lord, kindly.
Ramesh is petitioner number 4.
My lord, Ramesh is petitioner number 4, who is the purchaser. Chitra is the vendor. Now, my lord, if your lordship.
He had a brother also called Ramesh.
No, his brother was Chandan.
Chandan.
Chandan, my lord, the deed was executed in 2005. The remaining portion of the land, my lord, which she inherited from her father, my lord, she sold it to the petitioner number 4. In that deed, my lord, she signed as Chitra Bishwas. If your lordship takes up Annexure A, page 13 once, I have annexed the Aadhaar card of Chitra Bishwas, where her father is Chittoranjan, my lord, the original owner of the property. Now, my lord, the mother in 2024, my lord, comes up and says, my daughter was known as Binapani. Now, my lord, in a school records, she was Binapani. She was married with Dilip Bishwas. So, she is now Binapani Bishwas. One Chitra executed the deed. Chitra is Binapani. And, my lord, in the suit has also been filed.
Deed was executed by Chitra. Chitra and Binapani are two different persons.
No.
My lord, two deeds were executed, one in 1st of November 2022, another in 9th of January 2024. And on 7th of June 24, the affidavit comes that Chitra and Binapani are the same person.
But the Aadhaar card
After
shows
the
her father's name is
execution deed,
Chittoranjan.
they have made this my lord, affidavit.
No, these two, so what? If
But
they
heirship certificate
never
also-
imagine that someone will come up with this absurd proposition that Chitra and Binapani are different. That's why they have come up with that deed. The question is, was the same property conveyed by
Yes,
these
same
two?
property.
property same, but
But half portion was given to Chandan, remaining
Then
half
how
to
can it be the same property if half is given to Chandan and half
But
is
she inherited 1/3 share from her father. But that out of that 1/3,
1/3 he has given half to Chandan,
Chandan and half to my lord,
Ramesh.
Ramesh.
Correct. Now the thing is that in that document, in the subsequent deed, she has described herself as Chitra, not Chitra alias Binapani.
Binapani. But that is the only difficulty. Husband's name
But
is
in
same.
the heirship certificate also, there is no reflection of Chitra, only Binapani. Where from this Chitra comes, my lord?
And my lord, from page 13,
Price 41 is served, not complied
13
with.
and 14. Your 41A is only coercion. So why should they go? Petitioner contends that she is also known as petitioner contends that she is known as Chitra Bishwas alias Binapani Bishwas.
But the portion which my learned friend is describing as herself, but it's a property inherited. Whether there is any partnership deed with regard to that.
All right, that's a civil dispute. That is the civil dispute.
Otherwise, one of the transfers are all.
No, set them aside in a civil suit. There's no forgery. The petitioner contends that she is known as Chitra Bishwas alias Binapani Bishwas. She sold a portion. She had inherited a portion of the property from her late father. She sold one portion of her inheritance. She gifted one portion of her inheritance to her brother Chandan. Other portion she has sold to petitioner number 4. In the sale deed, she described herself as Chitra Bishwas. Chitra Bishwas. Full stop. This Chitra Bishwas subsequently, Chitra Bishwas taking advantage of this situation, instant case was registered. She pressed for anticipatory bail. Learned lawyer for the state contends Chitra and Binapani Bishwas are different persons. By impersonating as Binapani, petitioner has sold a portion of the property to petitioner number 4. She did not cooperate with the investigation. Learned lawyer for de facto complainant states that the property was jointly inherited by Chitra and other heirs. She did not have exclusive right to transfer in favor of a third party. We have considered the materials on record. Aadhaar card annexed to the petition shows Chitra Bishwas shows Chitra Bishwas is the daughter of
Chittaranjan Mondal.
Huh?
Chitra Bishwas is the daughter of Chittaranjan, my father.
Of late Chittaranjan Mondal. This prima facie establishes the fact that Chitra and Binapani are the same one and same person. With regard to the sale of a portion of the ancestral property to petitioner number 4, now with regard to the issue whether petitioner could exclusively sell the ancestral portion of the ancestral property to petitioner number 4, the same is in the nature of a civil dispute which may be adjudicated at the before the appropriate forum. Under such circumstances, we are inclined to grant and suitable.
Grateful.
Next.
My lord, I am for the petitioner, my lord. I am for the I am paying for anticipatory bail. My lord. Petitioner has been working as a Asa Kurmi under Ananta Kumar sub-center under Noda Gram Panchayat, Hemedpur Development Office block under additional mission director, West Bengal, my lord. Petitioner, but investigation officer served the notice under section 94 of the Bharatiya Nagorik Suraksha Sangha 1973, my lord. 2023, my lord. Finally, see, my lord, engagement letter, annexer P1, page 8. My lord, this is informing that Manjura Khatun, wife of such and such has been personally selected in the social health activity. Anantapur Sub-Center, Gram Panchayat, my lord.
Lord, may I kindly look at page 58, my lord. Page 58 of the case diary, my lord.
Madrasa certificate is not genuine.
Well, my certificate is genuine, but yes, my lord.
Want to see? This is the statement of the authority. Is the certificate in your custody?
Lord, a copy of that certificate is with me. From the Caesar list, I could found that a copy of that.
Why copy?
She has been absconding, my lord.
Please, sir. The certificate was submitted for the purposes of employment.
My lord.
So it will be with the employer.
My lord. Lord, we'll avail that original certificate.
Then get the why should person be in custody for that?
My lord, in this matter,
who are you?
De facto complainant.
Who are you?
I am de facto complainant.
So what is your interest here?
My interest is this: for submitting the fake certificate, my service has been terminated.
How can your service be terminated?
I was working as a Asha Kurmi, and I
all right, that fight will take place in writ court. Here she will
that
get.
Writ is pending, my lord.
All that writ dispute will be taken into consideration. Petitioner submits that the certificate relied by her is genuine. She prays for anticipatory bail. Learned lawyer opposes the prayer. Learned lawyer for de facto complaint also opposes the prayer. We have considered the materials on record. Petitioner was appointed as an Asha Kurmi on the strength of a certificate issued by madrasa.
Mark sheets.
A mark sheet issued by a madrasa. Report of the madrasa shows that the mark sheet is not genuine. does not appear to be genuine. Copy of the copy of the mark sheet is already in the custody of the investigating agency. Are you still continuing in service?
Yes, my lord. I am.
How? Why is she continuing in service after the FIR?
That
Kindly see, my lord, the engagement letter.
Engagement letter. That is on the strength of this fake certificate.
No,
How she is continuing in service?
on that count, my lord, let me file a report, my lord.
What? You are an investigating agency. You are not the employer. Custodial interrogation, under such circumstances, custodial interrogation is not necessary. Hence, we are inclined to grant anticipatory bail subject to conditions. Shall cooperate with investigation and hand over original certificate to the investigating agency. The order shall not stand in the way of the concerned from the authority concerned to initiate steps against the petitioner in accordance with law if so advised.
Miller, grateful.
Well, at 498 A 304B, I am the father-in-law. I am 69 years old. Well, at the wife in Kolani, I am a resident of Arambagh. Well, with the she, well, 1 year 8 months. Admittedly, the sessions judge, while granting other accused are on bail, sessions judge while granting bail found that they are residents of Arambagh and the husband used to live with the wife at Kolani. Kindly sees, my lord, the last page, annexure C, page 12. There is a finding of the sessions judge.
Landlady of the house gives a statement, page 6.
The allegation is against the husband.
Husband is on bail.
Mother-in-law and sister-in-law, not the father-in-law. Petitioner is the father-in-law of the victim lady. It is contended that the couple used to reside separately. He prays for anticipatory bail and a lawyer for the state opposes the bail, opposes the prayer. We have considered the materials on record. The couple used to, it is contended, couple used to reside separately. Allegation against the petitioners are general and omnibus. Under such circumstances, we are inclined to grant anticipatory bail.
Grateful.
Yes.
But I'm not pressing this appeal.
Not pressed.
But I'm for the petitioner. 341, 325, 326.
Not pressed.
Kindly sees the injury report, political fight between the two groups.
Injury are simple, man.
Injury are simple.
Yes.
And not the two person assaulted, they are on bail. It has been categorically mentioned by the complainant. Their names are Jabbar Sheikh and Jamirul Sheikh. They are on bail.
Case 44, another injury report.
Petitioner submits that there was a fight between two groups and they have been falsely implicated. The learned lawyer for the state opposes the prayer for ancillary bail. We have considered the materials on record, including injury report. Though victims were were hospitalized for 2 days, injuries are noted as simple. Under such circumstances, we are inclined to grant ancillary.
Your Lordship, I'm not pressing this application.
Not pressed. Next.
25 I'm for the petition, Lordship. Lordship 307, Lordship, family dispute, Lordship.
Nasal.
26th of infractuous. Charge sheet is not named in infractuous.
Petitioner is not named in the police in the charge sheet. Application is dismissed as infructuous, as not maintained. Next.
Let's say I am for the petitioner. Let's say petitioner is a labor contractor and victim is a labor working under the petitioner. But dispute arise regarding the payment and a case was registered. Charge sheet submitted in this case. Kindly see the statement of the witness.
This is the 164 of the victim.
Kindly see the statement of the witness.
10 lakh.
We have considered the materials on record. Petitioner had abducted the victim and demanded money. In view of the gravity of the offense, we are not inclined to grant answer.
I'm good.
For the petitioner allegation is that when the defector company was construction his house, at that time the present petitioner entered and assaulted his son. As a result, he was admitted in the medical college.
Out of 12 FIR name accused, 4 were arrested and still in judicial custody. My lord, kindly see the injury report. 3 persons were injured. My lord.
All right.
Your statement.
What about petition number 2?
Petitioner number 2.
And petition number 1, 80-year-old person.
His name is also there, my lord. Injured statement.
80-year-old person.
My lord, kindly see for a moment page number 213, 214 and 215, my lord. Last 3 pages.
From where are you saying he is 80-year-old? Where is the certificate for petition number 1?
My lord.
No? No, that is because at that time he was not 80 years. This is a Aadhaar card. The date of birth is we have considered the materials on record. Allegations are serious and is supported by medical report. Hence, we are not inclined to grant bail to 3 and 4, petition number 3 and 4. However, petitioner number 1 is an octogenarian and petitioner number 2 is a lady. Possibility of their false implication due to rivalry cannot be ruled out. Under such circumstances, we are inclined to grant ancillary bail to them.
Grateful, my lord.
Next.
29 for the petitioner, lordship. Lordship, allegation under section 341, 326, 307, 34, Lordship. For a land dispute, Lordship, regarding property distribution. Both case, counter case, Lordship. And Lordship, yesterday, Lordship, yesterday, Lordship granted co-accused bail, Lordship.
Ancillary bail.
Yes, Lordship.
We have considered.
Item number 23.
Lordship,
Heading is there, my lord, but final report.
Yesterday, you have gone to the report of Bohrampur. But what I find yesterday after the order was passed, petitioner was thereafter referred to Kolkata. CT scan was done, CT scan found fracture injury. All these are not part of the case.
Yes, that it is not
So
there.
kindly see, this is the
All right, what is the number of that case?
calculate yesterday.
23, Lordship. Item number 23.
Yesterday, item number.
Oh, case number.
Item 23, right?
Yesterday.
All right. 23 is placed today, day after tomorrow. Tomorrow. Both will be taken up together.
23 show a place for that.
order
ওই item 23 টা দেখো তো করতে।
This matter be placed along with 20.
That's it there.
I am happy. Lord, I beg to appear on behalf of the de facto.
Yes.
And I'm for the petitioner. And the petitioner has been arrested under section 196 and 299 of the BNS Act. And she has been granted bail before the Radnet court visa, and she has appeared before the concerned IO, my lord. Which case? In the Amherst Street police station case number 114 of 2024.
Granted bail.
In another case.
Oh, in another.
That is in connection with another.
That is garden reach, I hope.
Yes, he's in bail.
No, my lord. What my learned friend is claiming, my lord, it is in respect of garden reach. Now, my lord, this petitioner, my lord, is an habitual offender since 1 year. Now, my lord, she has a lot of criminal antecedents. She claimed herself to be an advocate who is practicing in Supreme Court. A case was registered. Now, my lord, there are cases where she has extorted money from the client saying that I'm an advocate. A case has been registered. This petitioner now, my lord, so far as this case is concerned, my lord, with deepest respect, my lord, made derogatory statements against the Prophet Muhammad. Now, my lord, several FIRs through the state of West Bengal, apart from that, my lord, outside India has been also registered. Now, my lord, so far as now the latest BNS Act, my lord, 38(3) has not been complied. My lord, she was asked to give the video details. She went to the office and she ran away.
Why should video details be given by her?
Yes, my lord.
Why should video details be given by her?
The mobile.
Lordship, I
The
have
mobile.
got the video details.
Yes. You have got it? Go,
If
go
your
and
Lordship
investigate.
wants to go through it, it is loaded in the mobile also, and I have
also
got
have.
the
I also.
chips.
Give a transcript. Place the transcript before us.
Lordship.
Transcript of the video publication be placed on record. Matter will appear 1 week hence. Petitioner shall cooperate with investigation. In the meantime. All right.
But my lord, petitioner is appeared before the concerned IO and she.
Go on appearing in the meantime as and when necessary.
Yes, yes.
And you produce the transcript of whatever is the video.
My lord, kindly allow the kindly allow my lord the anticipatory bail, my lord.
We want to receive what you have said.
No, my lord.
Huh?
No, my lord.
How can
Yes.
we allow or disallow until and unless we know what you have said? You have not set out what is the publication. So we want to know what is the publication by you.
Yes, sir.
Apart from that, 2 posts are there. 2 posts.
Sir, we want to know what is the publication.
All these, all the publications.
Strange.
If your lordship allows me, Lord, I have. Can I share this?
We are asking for a transcript.
Much of. So item number 31, I'm not pressing this application.
Not pressed. You filed 2 days ago and not pressed now.
Through WhatsApp, yes.
Huh?
Now he doesn't want to proceed with it.
So let him be arrested. Why
Cyber
this so-
fraud. Cyber
we
fraud.
do not understand. Cyber fraud, we understand. If you are serious in pursuing a person's custody, how is it that they have the luxury of filing a petition, withdrawing a petition? That's because your officer is conniving. An anticipatory bail application, we understand, is an application on a serious apprehension of arrest. We see applications filed on 6th. Today we are. It was noted. Date was 6th, so it has been filed maybe on 4th on the reopening. Within 2 days, wants to withdraw. Was 41A complied with in this case?
No instruction.
Then
Range. This was filed before vacation.
very good. Case was filed because vacation. So what is the steps taken by the investigating agents? Next.
Next one are the affidavits are.
For the petition, not pressing the application, surrender and got paid.
Not pressed.
Arrest. Get pullers.
Next.
Wait, please, Your Lordship. Allegedly, my lord, admittedly, from the house of one Kanon Roy, my lord, ganja of 29 kgs and odd was found. My lord, it was alleged that I was in possession of the house as a tenant. No documents are there, my lord, to implicate me as a tenant, my lord. Nothing was
Petitioner
found
has
from my
control and
possession.
Custody of the premises from where narcotics above commercial quantity, that is.
My lord, from source information, it was stated that it is his house. Now, the owner, Kanon Roy, has sent a letter and 161 statement is recorded on the following page. He says 3 years back, I have rented out the premises to this petitioner, but I do not have any receipt to show.
Very good. Control and custody of the premises where the quantity, that is, what is the narcotics recovered?
28 kgs and 380 grams of ganja.
28.380 kgs of ganja was recovered. Custodial interrogation with to unravel the complicity of the petitioner in the crime is necessary. Accordingly, we are not inclined to grant answer.
My lord.
Next.
My lord, 35. I'm for the petitioner, my lord. 363, 365, my lord. My lord, the two major person, my lord. Daughter of the petitioners, my lord, and the son of the complainant, my lord. They eloped together, my lord. Victim girl is, my lord, we are the parents of the girl, my lord.
Victim recovered.
My lord, they are living together, my lord.
Has she been recovered or not?
35, my lord.
Victim recovered or not?
No.
My lord, If your lordship permits me,
Let
my
the
lord, at
victim
2 p.m.
go and make a statement before
If
magistrate.
they are here, my lord, in call,
We are not the magistrate. Victim will go and make the statement before magistrate.
my lord.
Petitioner submit that the victim and who is and the son of the petitioners are residing together.
No, my lord, daughter of the petitioner. We are the parents of the daughter, girl,
Oh, the boy is missing.
boy
The
and
case
girl.
and counter case by all right. The petitioners contend that the victim and their daughter are residing together. Investigating agency shall take steps for recording the statement of the victim before magistrate under section
Victims,
1. Victims before magistrate under 183 BNSS. Full stop. Petitioners shall not be arrested for 2 weeks. Matter will appear 1 week hence.
Grateful, my lords.
Communicate karo. Communicate karo. Bolo duto case Yes, Mr. Mukaram Hussain.
The allegation
For the petition, my lord. The loan transaction, my lord, I have given, I am the bank manager, my lord. 468, 467, my lord.
Yes.
406, my lord.
He is admittedly a bank employee, my lord, but there are certain anomaly regarding his actual possession, seizure of the vehicle, and the documents that has been submitted. That is why this forged, my lord, for. '27. In one of the documents they are saying, but when the stock registered is being seized and that register is showing that they have actually seized the vehicle long back. That is on.
But then how that?
But that those are all matter of trial. They are saying that these are the forgery documents that has been created by the bank. And all.
Petitioner is a bank employee. He play any role in preparation of the alleged repossession certificate. Co-accused has been granted anticipatory bail. We are inclined to extend the same relief.
May I?
My lord, there is a correction in the
Which
cost
is
center.
the de facto complaint.
May I,
Liberty,
sir?
my lord.
The permission of my lord, may I speak something in front of court, sir? Sir, I have some points regarding this court, as I am giving some documents here which is totally fabricated or it is just false paper. But sir, my one question for the bank, may I speak in Hindi, sir? I'm comfortable. सर मैं एक चीज बोलना चाहूंगी सर, वी ऑल एज अ पर्सन हम लोग ट्रस्ट करते हैं कि बैंक ऑनेस्टली दे आर फॉर द पीपल और दे आर जस्ट फॉर अ सोसाइटी। बट इस केस में सर एक यूनिक चीज देखने मिलेगा सर, उन्होंने एक नहीं 7-8
पेपर जो बिल्कुल भी जरूरी कागजात बोलेंगे इनिशियली से लेकर के स्टार्टिंग टू एंड तक, वो फॉर्ज करके बनाया है, फैब्रिकेटेड बनाया है, और वो पेपर खुद ही सर बोल रहे हैं। ऐसा नहीं कि मैं आपको बोलूं कि सर आप देखें कि मेंशनिंग इन्होंने क्या किया और बोल क्या रहे हैं। सर ये सिर्फ अपने क्लाइंट्स को लोन देने के बाद एक प्रेशर बनाते हैं उन चीजों को कि मैं आपको प्रेशर करूंगा, आपसे मैं झूठ भी बोलूंगा, आपको फॉल्स पेपर भी दूंगा, और आप अगर मुझे अल्टीमेटली मेरी बात नहीं मानेंगे तो मैं उन चीज आपकी
यूज
गाड़ी
करेगा।
को बेच भी दूंगा। और सर इस चीज में यूनिक की चीज देखेंगे कि गाड़ी थी मुजफ्फरपुर की, चल रही थी यहाँ ऑन रोड, उन्होंने उठाया।
Did your client repay the installments?
Yes, sir. My client in 29 lakhs, my client pays 21 lakh. It was a
Right.
corona period, and he was also at that time he was severely in as a patient. He was admitted, but he paid 21 lakhs. It is
So
like,
the entire amount has not been paid. The petitioner contends that जेटा वही de facto complaint
इन्होंने तो इतना हद कर दिया है कि कोर्ट को भी सर ये फॉर्ज पेपर देने में डरे नहीं है। सर कंज्यूमर कोर्ट में भी हम लोग खड़े हैं इस केस को लेकर के, वहां पर 5 पेपर सर प्री सीजर, पोस्ट सीजर, डीटीओ को दिया।
Madam, we understand all these things, but so far as your repossession of the vehicle is concerned and getting back of the vehicle, until and unless you liquidate your dues, the repossession, just because the certificates are antedated or post-dated, will not help you. And ये क्रिमिनल केस में ये कागजात तो पुलिस के पास ऑलरेडी है, तो इसीलिए इसको अरेस्ट करके क्या एडिशनल बेनिफिट होगा? The most important thing is to decide how much is outstanding and whether you are in a position to liquidate that. Immediately that is done, or if there is unfair interest charged, that can be squared out and the dues can be reformulated, or you can get a clear picture of what is the outstanding due. But ये criminal case में तो आपका जो problem आप बोल रहे हैं, we cannot give you that assistance. Then a lawyer for the de facto complainant contends the bank officials had prepared fabricated documents and taken repossession of the vehicle. They have even utilized those documents before the consumer court. Though we have considered the materials on record, the alleged documents are in the custody, are in the custody of the investigating agency. Custodial interrogation for obtaining the documents is not necessary. The other issue in grievance of the petitioner with regard to illegal seizure of the vehicle may be adjudicated before the appropriate forum. In light of the aforesaid circumstance, co-accused has been granted anticipatory bail. In light of the aforesaid circumstances, we are inclined to extend the same privilege to the petitioner. We have passed the anticipatory bail order. We have said that your grievance with regard to repossession will be decided by the forum. All right.
And liberty to correct the cost title, my lord.
Other matters will come after 5 minutes.
Great.
College friends. Yeah. Yes.
My lord, relaxation of condition of.
Yes. We have the jurisdiction.
Yes.
You
Your
have
lordship
complied
was-
with the condition.
Yes, my lord, that is the instructions that I have complied
Petitioner
with.
has complied with the condition of ancillary bail / regular bail. Accordingly, we direct that the petitioner, what is the condition?
My lord, the condition was that he will not enter within the jurisdiction of the concerned police district North Chobbish Pargona and shall give an hajira before the officer in charge, the concerned police station where he shall be residing.
Petitioner, that the petitioner shall not enter the jurisdiction of North 24 Parganas and shall report to the officer in charge of the police station concerned where he shall presently reside once in a week is waived. He shall report to the officer in charge Harwa police station once in a month until further.
But I'm for the petitioner. But the co-accused has been granted. But co-accused has been granted bail by your lordships lastly on 7/8/2024, my lord. Two of them are renewing their bail prayer, my lord. One is,
How long you are in custody?
my lord, one is petition number 1 is on 750 days. Petition number 2 is 874 days, and petition number 3 is 878 days.
Lordship, trial is continuing on the last schedule, which was fixed in September 27, due to the expiry of the mother of the learned judge. So that was not able to complete.
Okay.
Next schedule is on 30th January to 4th of February,
Main,
and only 9 witnesses are left. So for our
the
instruction.
main ground that was
And from the house of PW3, this contravent was seized, and from the spot, PW2 was arrested, Lordship. And so far,
Just don't stand on the same footing.
from
my lord, the
And
main
the-
witness, Caesar witness has become hostile, man. That
no,
was the
Lordship,
ground.
that was not turned
Irrelevant.
against her. The Caesar list witness of
Irrelevant.
these CSW 8 and 9 not
Whereas they
examined.
stand in the whereas the Pintu De Sarkar, from whom the entire recovery was made, he has been granted bail.
No, from Shubhankar Borman. Shubhankar Borman allied Shubho, Lordship.
Whereas there are other two accused persons who has been granted bail, they were also recovery was made from them. my lord.
Caesar list was
These
made in
accused
several
persons
times,
were-
and there are several Caesar list witnesses, Lordship. CSW 8 and 9 were the Caesar list witness from whom who were present at the time of Caesar of the contravent articles from Shubhankar Borman from the house of Gopal Borman. They were not examined.
Whereas my lord may kindly comes to the depositions, my lord.
Caesar list page 8-9. 8-9.
Witness number 9123.
CSW. Hmm.
Recovery was from whom?
Recovery is from Shubhankar Borman.
Huh?
Shubhankar Borman.
Shubhankar Borman. Where is he?
He's in custody. Petitioner number 2 from the house of Gopal Borman. Gopal Borman is the father.
Father.
Hmm.
And Rinku is?
Rinku is the different person. PW2 named Rinku. PW1, Lordship.
Telephone conversation.
But no CDR was in the case. So what is the petitioner number 1?
Rinku was rejected earlier.
Yes, ma'am.
Because there were statements of the wife
Rinku's
of
name was-
Rinku
yes, Lord.
that he is dealing in
But
narcotics.
no CDR was there. Yes, that statement is there, but
That
no
wife
CDR.
has been examined.
She has not been made
The wife
witness.
is-
She has not been made witness, ma'am.
হোয়াইটের নামটা কি ছিল?
There are independent witnesses saying that Rinku
হুম
had entered into conspiracy.
হুম হুম Independent means Saurabh Pal, Ratan Chaudhary, not examined, Lordship. Not examined. On the last schedule, they were supposed to examine, but due to the they were
Dr.
not,
Chaudhary and Saurabh Pal was to
not
be examined.
examined. CSW 8 and CSW 9, not examined.
When is the next date?
Date is the 30th of January, 31 to 4/2.
Let them be examined, then we'll consider your plea.
Madam, kindly then can
Regular bench.
My lord, I am for the petition. My lord, nothing was recovered from the petitioners. My lord, my prayer for bail I have not pressed because at that time charge sheet was not, complaint was not submitted. That is page 12. It has been
Petitioner is in
recorded.
custody for
My lord, petitioner number 1 is in custody for about 6 months. Petitioner number 2 is in custody for about 5 months.
petitioners are in custody
So
for
they are-
6 months and 5 months respectively. No narcotics was recovered from their possession. What is the complicity?
My lord, they are transporting, my lord, ganja 21 kg commercial quantity to the Bangladesh, my lord. They
Correct.
are using, my lord, at the day of seizure, my lord, this petitioner and my lord, whose possession, my lord, seized, both are, my lord, same place. That, my lord, tower location of the mobile and CDR call, my lord, they have call with the Bangladesh, my lord, several, using the Bangladesh mobile SIM also. That were destroyed. Not only that, petition number 2, my lord, previously arrested, my lord, 2006 in the cattle smuggling by the Bangladesh police.
My lord, seizure was
Third
from
page of the
Bishu
report.
Mondo. 21 kgs of ganja from Bishu Mondo.
Third page of report. No, Bhim Biswas, my lord.
Bhim Bishas.
Bhim
My lord,
Biswas.
I stand corrected.
This petitioner, my lord, escaped from that place.
Bhim Bishas.
Only Bhim Biswas was arrested, my lord. That is possession, my lord, 21 kg. Ganja was seized.
Yes, but there is no tower location. You
Yes.
just say that he was using a Bangladesh SIM card, Laltu Ghosh.
No, my lord, third page, my lord, last paragraph. CDR established mobile connection on the day of seizure,
Wow.
and tower location was
Once again,
same on
once
the
again.
day of
This is
seizure.
Laltu Ghosh, na?
Laltu Ghosh and Rajat Bishas.
Huh. Come to role of accused, Laltu Ghosh.
Next, my lord, Rajat Biswas, and my lord, last paragraph, note. Roman 1 to 3, my lord.
And that is with regard to Rajat. That is with regard to Rajat.
The statement of the, my lord, Bhim Biswas was that both the petitioner were with their, my lord. On next page, my lord, there is
Next page.
mobile call, my lord, there.
These phone calls on which days?
This call, my lord, previously, my lord, there. Before the, my lord, day of,
The phone calls.
yes, my lord. They are transporting, my lord, ganja with the Mojid Mia of Bangladesh.
Recovery was from Moji.
Bhim
From
Biswas.
huh?
Recovery from Bhim Biswas.
Bhim.
Yes.
Bhim Bishas.
Tower location is a good. Your tower location is more important than if you can show the tower location at that time, at that place.
Yes.
We have considered the petitioner content. No narcotics was recovered from the petitioner. He pays for he pays for bail and a lawyer for NCB oppose the bail prayer. He contends that petitioner number 1 was using a Bangladesh SIM card and made international calls to a to one Mujid Mia, a Bangladeshi national to whom narcotics was to be supplied. Tower location of the mobile phones of the petitioners matched with that of co-accused Bhim Biswas from whom narcotics was recovered. We have considered the materials on record. CDRs show telephone a Bangladeshi SIM card. A Bangladesh SIM card was recovered, was being used by petitioner number 1 to contact one Mujid Mia, another Bangladeshi. Full stop. Tower location of both the petitioners were had matched with co-accused from whom narcotics is recovered in view of the aforesaid incriminating materials, which showing which disclose nexus between the petitioners and co-accused Bhim Biswas in smuggling narcotics across international border, and we are not inclined to grant it.
Grateful.
Next.
My lord, may I please, your lordship? Well, this is my application. My lord, petitioner was arrested on 1/1/2024. My lord, he is in custody 10 months. Charge is submitted on 26/6/2014. Nothing was recovered from his possession.
Yes.
Charge not yet framed. My lord, one of the accused person was already enlarged on bail by your lordship.
Your
All them
lordship
now.
had granted this order on 11th of September, my lord.
Yes. 9th of September.
Yes, he stands on the same footing. Petitioner
this
is in
petition.
custody for 100 days. Co-accused Mohammad Dilan Nawaz was enlarged on bail. Petitioner stands on same footing with the said co-accused and is entitled to similar relief. Hello. Next.
My lord, I am for the petitioner, my lord. My lord, allegation under section 21C 29 of the NDPS Act, lordship, nothing has been recovered from me, lordship. My name came from the co-accused statement, lordship.
And all other persons were fled away when BSF personnel were caught 1 person with 751 bottles of fentanyl. They are all fled away.
We have considered materials on record. No narcotics was recovered from the petitioner. His complicity transpires from statement of co-accused before police officer, which is inadmissible in evidence. Under such circumstances, we are of the opinion petitioner has been able to reverse statutory decisions at of NDPS Act and may be entitled. Next.
Grateful.
Wait, please, your lordship. But 2 years, 9 months, and 4 days in custody. Out of, my lord, 13 witnesses, 6 witnesses have been examined. Charges framed in the year of 2022.
Petitioner is in custody for 2 years and 9 months. There is inordinate delay in trial. He prays for bail and a lawyer for the state opposed the bail prayer. We have considered the materials on record. Though 45 bottles of phencyl syrup containing codeine phosphate was recovered from petitioner, he is in custody for a considerable period of time. Prosecution, how many witnesses examined?
6 witnesses examined out of 13.
3 out of 13 witnesses have been examined till date.
6 out of 13.
6 out of 13 witnesses. There is no possibility of conclusion of trial in near future. Petitioner has made out a case for bail on the ground of delay in trial. Delay in trial, bail prayer on the ground of delay is not restricted by fetters under Section 37 of NDPS Act. Accordingly, we are entitled to grant.
I'm grateful to you.
Next.
My lord, I am for the petitioner, my lord.
Yes, Mr. Maithili.
Lord, in this matter, my lord, your lordships were pleased to, my lord, ask me to appear, my lord, since no one appeared in this matter, my lord, because I am appearing in one of the matters, my lord, which is still pending, in which, my lord, yes, my lord, the last order which was passed by his lord, by the coordinate bench of this honorable court, my
What
lord.
we are doing is, we are enlarging him on interim bail and placing the matter before the coordinate bench.
Yes, my lord. On 18th, my lord, is the date, next date fixed of the other, my lord, order,
That
my
is
lord.
why petitioner stands on same footing.
And the
with
13th is the
accused
next
who have
date
been
fixed for, my
enlarged
lord,
interim bail.
recording evidence.
Petitioners shall be enlarged on interim bail on similar terms and condition. List the matter along with CRM NDPS 1381 of 2024 before the regular bench. Interim bail shall continue till 30th of November or until further orders, whichever is there. Next.
My lord, I am for the petitioner. My lord, co-accused statement. My lord, 106 days I am in custody.
My lord, the petitioner has called CDRs with the owner of the vehicle from which contraband was recovered. The anticipatory bail application of the owner of the vehicle has been rejected by this court. He's still absconding, and he has 2 antecedents as well of
My lord, I have got acquittal in those cases. I have got acquittal. My lord, one is
The owner of the vehicle is absconding.
one is Gwal.
Owner of the vehicle is absconding.
My lord, I am not connected with the owner, my lord.
His
anticipatory bail application was done. What conversations used to take place? Did
My
the
lord,
owner get arrested thereafter? Regular bench.
deep lord.
Deep lord.
I am for the petitioner, my lord. Allegation under section 21 C of NDPS Act, my lord. 2.5 liters of contraband article has been seized. The petitioner.
8 kgs codeine. Case of November 2023, charge has been framed. 2 witnesses
We have
examined out
considered
of
the
70.
materials on record, statements of witnesses and contemporaneous document that the Caesar memorandum show recovery of 2.6 liters of codeine mixture from petitioner. Charge investigation is complete and charge has been framed. Under such circumstances, in review and in light of section 37 of NDPS Act, we are not inclined to grant.
It will be 2.68 kg.
2.68 kgs of codeine mixture.
Great.
Next.
Lord, I bring for the petitioner, my lord. Lord, the 21C of the NDPS Act, my lord, nothing has been recovered from the possession of the petitioner, my lord, but only on the basis of co-accused statement, my lord. The another accused person named, my lord, the Mohammed.
We have considered materials on record known.
Mohammed Allah.
You are the registered owner of the vehicle.
Mohammed Allah, my lord.
Petitioner, we have considered materials on record. Petitioner is the registered owner of the vehicle, which was used to transport narcotics. It is in view of the aforesaid materials. We are of the disclosing involvement of the petitioner in the transportation of narcotics, and in light of statutory restriction 37 of NDPS Act, we are not inclined to grant.
Nothing has recovered from the possession, my lord.
You own the vehicle which was used.
Nothing has been recovered from the possession of the petitioner based upon co-accused statement, charge sheet submitted. I am in custody for 70 days.
Yes.
Khalid, he was the person who was the recipient, Khalid, of the property, And there were conversations between the person who was apprehended and this person. Malad, there is one criminal antecedent, Malad, of Explosive Substances Act, Malad, on which he is on bail. 2,000 bottles of fentanyl.
Petitioner is in custody for
70 days.
70 days. Investigation is complete. No narcotics was recovered. Learned lawyer, he prays for bail. Learned lawyer for the state contents. CDR show telephonic conversation between the petitioner and co-accused from whom narcotics was recovered. We have considered the materials on record. Complicity of the petitioner is based on all detailed records showing conversation between petitioner and co-accused from whom narcotics was recovered. The contents of conversation are unknown. Under such circumstances, we are of the opinion petitioner has been able to reverse statutory restriction of 37 of the NDPS Act and maybe entitled to pay.
Special court NDPS.
Next.
I am for the petition.
I am for the state.
I am 3 months in custody. And only 2 out of 15 witnesses have been
My lord,
examined.
on 27th of September 2023, Lordship was pleased to reject one of the accused persons bail pair, and thereby my Lordship was pleased to direct within 1 year the trial would be concluded. My lord, thereafter, for the latches of the prosecution, my lord, we have not taken time. Only, my lord, PO was on leave 6 days. My lord, court vacant 1 day. 1 day, my lord, witness was absent. Local bar, my lord, absence from their work 1 day, and witness
for
not
more than 3 years.
That is the position.
You are 3 years in custody.
3 years, 3 months in custody.
14 witnesses out of
Petitioner is
14.
in custody for over 3 years and prays for bail. He further contends that trial has not concluded in spite of direction by this court in CRM, direction by this court in CRM NDPS 161 of 2023 to conclude trial within a year. Within a year. When was this order communicated?
The 27th of September 2023 was the order passed.
No, thereafter, 1st of August 2023, my lord, the charge has been framed. No,
you give a report.
My lord.
Report with regard to status of the proceeding and reason for delay be filed. Matter will appear 1 week hence.
1 week.
Next.
1 week.
Madam, I'm for the petitioner. But this is my renewal application. I am in custody for 1 year, 1 month. 398 bottles of fentanyl was recovered. Out of 10, only 4 has been examined.
Petitioner is in custody for 1 year, 1 month.
10 months, 1 year,
1 year, 10 months. He submits there is delay in trial. He prays for bail, and a lawyer for the state produces the case diary. We have considered the materials on record. Petitioner is in custody for about 2 years. How many witnesses have been examined?
My lord, 4. Out of 10, 4 examined.
4 out of 10 witnesses have been examined. There is little possibility of trial concluding in near future. Under such circumstances, we are inclined to, we hold petitioner has made out a case for bail on the ground of delay in trial. Or bail prayer is not restricted. Hello.
Great.
Next.
May I please, Lordship? My lord, the petitioner is in custody for almost 5 months. My lord, in this case, the petitioner is the purported recipient, my lord, of the contraband, my lord, which is about 20 kgs, 939 grams of ganja. My lord, one Saraswati Borman, along with her husband, my lord, where they were traveling to Shialda station. And over there, my lord, there was about 20 kgs, 939 grams of ganja, which was there, which was supposed to be handed over, my lord, to this petitioner and one Oshim Roy. Now, my lord, this was received from one Ujjwal Roy. My lord, as far as the husband and Ujjwal Roy are concerned, they were absconding. my lord, the petitioner was arrested and my lord, he's in custody since then. My lord, as far as the FIR and the charge sheet goes, my lord, it shows that the possession of that ganja was with Saraswati Bormon herself. My lord, that is at pages 12 and 21 of the charge sheet, my lord. My lord, trial has not yet begun, my lord, subject to
Petitioner is
correction.
in custody for 6 months. He contends that the narcotics was not recovered from his possession. He prays for bail. Learned lawyer for the state opposes the bail prayer. He contends that petitioner was present at the spot and the contraband was to be handed over to him by the co-accused. We have considered the materials on record, manner and circumstances in which the recovery took place. Prima facie establishes complicity of the petitioner in the crime. Co-accused had brought narcotics, that is, narcotics have a commercial quantity that is 20.939 kgs of ganja to be handed over to the petitioner. Petitioner was also present at the spot. At the time of the transaction, they were apprehended. In light of the aforesaid circumstances and statutory restrictions on the 37 of NDPS Act, we are not inclined to grant.
MD Brigade.
Head.
Lord, I am for the petitioner, my lord. No recovery from my possession, my lord. Other accused persons has been granted bail by your lordships, my lord. Here is the order, my
We
lord.
have considered the materials on record. No narcotics was recovered from the petitioner. Co-accused have been granted.
Not from him, my lord. The seizure was not from him, not from the petitioner.
No, others have been granted bail.
One co-accused has been granted bail. Pursuant to whose statement he was arrested. He has been granted.
Co-accused have been granted bail. Under such circumstances, we are inclined to extend the same privilege to the petitioner. Hello.
Grateful.
My lord, I am for the petition.
Yes.
My lord, I want to not press this application.
Not pressed, dismissed.
I love Leicester.
Next.
56, my lord, I am for the petitioner. The petitioner is in custody for 2 years, 6 months. 24.5 kg of ganja was recovered from 7%. My lord, page 16 onward, your lordship also page 14, your lordship also granted bail.
Year and 6 months. Co-accused have been enlarged on bail. He prays for bail. Learned lawyer.
All of the accused are absconding presently, and so far as this petitioner is concerned, lordship, pursuant to his statement, 3 were detained, and from them there was a further recovery of 7.7
Alright.
kgs.
Learned lawyer for the state submit co-accused are absconding. Recovery was made pursuant to the leading statement of the petitioner from other accused. We have considered the materials on record. No narcotics was recovered from. Anything was recovered
From him also, lordship.
Acha.
24.
We have considered materials on record. Petitioner is in custody for a considerable period of time. Trial has commenced.
My lord, no, my lord.
Charge has been framed but not progressing right now because of
Examination of witnesses have not yet commenced. Prosecution proposes to examine. How many
How many witnesses করবে তোমরা?
lordship 24.
24 witnesses. There is no possibility of trial concluding in near future or delay in trial. Allowed.
Grateful, your lordship.
My lord, 57.
Lord, I'm appearing for the
custody
Lord.
for 2 years, more than
NCB.
2 years, 4 months. My lord, co-accused is enlarged on bail. My lord, page 8. My lord, charge has been framed, my lord, long back, my lord, 16 September 2023. Till date, my lord, only PW1 examined, PW2 partly examined.
Yes.
Total
And
5
next date
witnesses.
is fixed on Milord 20, Milord 2nd and 3rd December 2024, Milord.
Petitioner is in
And
custody
Milord
for 2 years
4 months,
and 4 months.
28 days.
There is inordinate delay in trial.
Milord, this is the Milord report, Milord.
Co-accused
Perhaps soft copy.
Ajit has been enlarged on bail. He prays for bail. Lawyer for NCB places report on record. From the report, it appears that
On
one
PO case,
prosecution witness has been examined in full and another has been
out of
examined
6.
in part.
Out of 6.
Prosecution proposes to examine 6 witnesses in all. We are of the opinion there is little possibility of trial concluding in near future. We are under such circumstances. We are of the opinion petitioner has made out a case for bail on the ground of delay in trial. Co-accused has also been released on bail. Accordingly, we are inclined to enlarge the petition.
Diploma. Yes. Lord, for the petitioner, but this is my renewal application. This is case of no recovery. From my position, nothing has been
Your
recovered.
Lordship will see the order of rejection, my lord, annexed at page 9, my lord. 1st of April, your Lordship.
You have considered the materials on record. Bail prayer of petitioner was rejected early in April 2024 on merits. Thereafter, what has happened? Trial is continuing. Why?
My lord, the next date is fixed on 25th of January, my lord.
How long?
My lord, he is in custody for about 410 days.
410 days.
Yes, my lord. Yes.
Kudush Mondol.
Initially 240
1 year,
days.
3 months.
When
1
the
year,
last
3 months in custody.
Delay in the matter is due to abscondence of the petitioner for 2 years, for more than 2 years.
More than 2 years. He was arrested in 2023 only.
When I was shown arrested, my lord. I'm in custody in another case.
Arms Act case.
And
He has
I was
criminal antecedents. Accordingly, we are not inclined to grant bail at this.
Great. Obliged.
Next.
59, my lord, for the petitioner, but this is premature application. My lord, the bail period of the petition was rejected in
Earlier,
June
my lord, when it was
2024.
rejected, 6 months was granted, my lord, to complete.
Petition bail prayer of petitioner was rejected earlier on merits in CRM NDPS 111018 of 2024. While rejecting the prayer, this court directed trial to be concluded preferably.
Now, page 10.
A coordinate bench directed
To conclude that act
concluded
at an
within
early
6
date.
months. The said
Within 6 months.
time frame has not expired as yet. You wish to pursue this application?
My lord, may I withdraw this application?
Not placed. Accordingly, petitioner prays to withdraw the application. Application is dismissed as well. Next.
Lord, I am for the petitioner, my lord. No narcotics record from me, my lord. Based on the statement of co-accused, my lord, others have been granted bail. Co-accused persons have been on bail. Enlarged on bail.
No narcotics. We have considered petitioner is in custody for
My lord, 1 year, 4 months, 25 days.
1 year and 4 months. No narcotics was recovered from his possession. Co-accused, similarly circumstanced with the petitioner, have been enlarged on bail. Accordingly, we are inclined to extend the same.
Grateful, my lord.
Next.
That's the for the petition. That's the first application, 125 bottles of fentanyl. Petitioner is a custody 1 year, 6 months. Till there, no witness turn out of 15. Only charge fame. 1 year, 6 months, I am custody.
From the exclusive possession of this petitioner.
But no witness?
No,
Why?
not yet.
How many witnesses?
Total 15 witness.
Witnesses.
Petitioner is in custody for 1 year, 6 months. He submits there is delay in trial. He prays for bail and a lawyer for the state oppose the bail prayer. We have considered the materials on record. Petitioner is in custody for 1 year and 6 months. Amount of amount of narcotics seized is of commercial quantity. Petitioner is in custody for a considerable period of time. There is no witnesses have charge framed.
Yes, ma'am.
Yes.
Prosecution proposes to examine witnesses, but no
2011, 24 is
witness
the
has been examined till date. Under such circumstances, we delay in trial. Hello. Next.
For the petition. This is my renewal application. I am in custody for 2 years, 7 months, 24 days. Out of 20 witnesses, 8 has been examined.
Petitioner is in custody for more than 3 years, 7 months.
2 years, 7 months.
2 years, 7 months. He submits there is delay in trial. He prays for bail and a lawyer for the state opposes the bail prayer. We have considered the material on record. Two allegations involved.
20,000 pieces of methamphetamine tablet.
Recovery of 20,000 pieces of methamphetamine weighing about 2.2 kgs. Petitioners are in custody for a considerable period of time. How many witnesses?
8 examined.
8 already examined, my lord.
8 out of
20, my lord.
20.
Out of 20.
8 out of 20 witnesses have been examined. There is little possibility of trial concluding in near future. Under such circumstances, we are of the opinion petitioner has made out the case for bail on the ground of inordinate delay in trial, bail prayer on the ground of delay, so and so on.
Grateful.
Allowed. Next.
Lord, this is the first time I'm approaching your lordship, my lord. I'm in custody for 2 years and 4 months, precisely 27 and 21 days. My lord, 2 of the co-accused persons have been granted. My lord,
I will
2
wait for not today.
Why?
I'm yet to receive the case date.
Not today.
No time applying for the petitioner.
Another 10.
On 9th of March, the deceased went to meet with one Josimuddin. On 10th of March, since he did not return, his wife lost a missing diary. On 12th of March, his dead body was recovered. Josimuddin He's going to meet with one Josimuddin. On 10th of March, a missing diary was lost by his wife. On 12th of March, his dead body was recovered. Josimuddin was arrested. From his leading statement, offending weapon was recovered. So for this petition is concerned Miller, there is no such implication. He is in custody for 135 days. Charge sheet has been submitted, Miller. Another co-accused person has been granted bail by the
There is a statement of an eyewitness saying that all these persons were together present at the time when they were taken in a van. Number two, there is a lat-long report which shows this present petitioner and the deceased was in the same place where from the body was recovered. It will kindly peruse that 164 first at page 228. This is the lat-long, I have told you.
And the lat-long report is with regard to the time of occurrence.
Yes, yes.
Yes, sir.
And where is the statement?
That is at page 228.
Please, ma'am, bail page पर भी send putting in.
You don't believe that that's another story.
Her name Jahangir Alam.
Who was murdered?
Jahangir Alam. Jahangir Alam.
Jahangir. So Jahangir is Joshim's brother-in-law.
There are two Jahangirs. The present petitioner is also Jahangir. The deceased is also Jahangir.
In the 164 statement, the deceased is not there.
This is Jahangir is there. Marad will kindly look into. Jahangir is there. He was speaking with Jasim, his relative Jahangir, and Rocky came. Jasim with others went in the van, wherein Mozammel and Joinal was driving the van, and Jahangir, Rocky was sitting in the van.
Yes. When the vehicle goes, the four persons that he sees is Mujammil is driving, Jahangir and Rokib are sitting. There is no victim Jahangir in that vehicle.
No, may I just come back?
Yes.
May I just
come back?
It's not today, Marad. Let me go through it again.
Not today.
For the petition. 498 and 306, added section 306. The husband and the father-in-law has already been granted bail by the honorable. And the sister.
How did she die?
But case there is not with me, but we have
Bond. 4.5 years to pass.
Given bail 12 years after marriage.
12 years after.
Keep it after day after tomorrow.
It's 7 to 10.
Who are you?
Well, I am the sister-in-law. Husband and
Petitioner is the sister-in-law of the victim lady. Incident occurred 12 years after marriage. She is in custody for
4.5 years.
4.5 years.
Yes, ma'am.
There is a
Alright, let the
statement
case
of the
diary be brought.
minor also. Minor, can you make it not today, at least?
Not to. Nothing to say. Yes.
May it please your lordship, my lord, this is a case registered under section 395, 397. My lord, there were 12 unknown miscreants. So far as this petitioner is concerned, my lord, test identification parade was conducted. My lord, I have not been identified. And in this case, my lord, I have been shown arrest. My lord, I was in
booty, recovery of booty, and that part, my lord, has been identified by the de facto complainant. And he has been placed in the TI pad, but he has not been identified. Our antecedent is there because he has been shown as same crime.
Petitioner
My lord, will kindly see
that
the
he was not identified during TI parade examination. He is in custody for
7 months, more than 7 months.
7 months. He prays for bail and a lawyer for the state submit. Stolen articles were recovered from the petitioner. They have been identified by the complainant. We have considered the materials on record. Stolen articles have been recovered, which have been identified by the complainant. Petitioner has criminal antecedents. Under such circumstances, we are not inclined to grant it. Next.
No, 307, 354. I'm in custody since 18 June 2024, 150 days. Charges submitted on 30th June 2024. And since then, there is no progress in trial, neither copies of nor charge film.
How long you are in custody?
Sole accused, case counter case, and this petitioner is.
Not the statement of the victim and the husband that the petitioner tried to outrage the modest. Husband tried to save when he was hit with the hasua. He admitted in the hospital for 3 days and inside.
How long you are?
My wife.
How long you are in custody?
150 days.
Petitioner is in custody for 150 days. He contends there was a free fight. Case and counter case were registered. Investigation is complete. He prays for bail. And a lawyer for the state submit. Petitioner had outraged the modesty of a lady. When her husband intervened, he was hit with a haswa. We have considered the materials on record. Case and counter case have been registered over the self-same incident. Investigation is complete. Injury does not appear to be life-threatening. Under such circumstances, we are inclined to grant bail subject to condition meet officer in charge once in a while. Next.
I'm for the petition. 498, 306, 304, 34 of the Indian Penal Code. Petitioner custody for 333 days. Charge sheet submitted. Petitioner is the husband.
Did she die?
Hanging.
My lord, hanging within 1 month of the marriage.
Petitioner is in custody for.
Who accused?
Petitioner is in custody for
333 days.
333 days. He submits. He has been falsely. He submits. He has been falsely implicated. He prays for. There is no possibility of conclusion of trial in near future. He prays for bail, and a lawyer for the state opposes the bail prayer and contends that the victim housewife committed suicide within
1 month of marriage.
Within 1 month of marriage. We have considered the materials on record. Victim housewife had committed suicide. Investigation is complete. Petitioner is in custody for about a year. 9 months, huh?
11 months.
For 11 months. For about a year. There is no possibility of trial concluding in near future. There is no chance of abscondence. Accordingly, we are inclined to grant bail. Next.
Efficient common law.
The allegation annexes 498 304B 34 railway section 304 Dowry Prohibition Act. It is saying husband given custody for more than 8 months, all other has granted bail, charge has been submitted.
Within 2 years of marriage, my lord, and this is the
If we have
postmortem
considered the materials on record, victim died due to hanging, which is indicative of suicidal death. Allegations of torture are general and omnibus. Investigation is complete. Petitioner is in custody for 8 months. Petitioner husband is in custody for 8 months. Investigation is complete. There is no chance of abscondence. Accordingly, we are inclined to grant it. Next.
A petitioner is in custody since last 17th August 2024. He surrendered himself before this court. The main co-accused in this matter was enlarged on bail by the learned court below, along with one more co-accused, Noor, Your Lordship.
What is the offense?
Offense is under section, Your Lordship.
All right, they're going to find the file passed over.
Pass over.
71, my lord. This matter, my lord, your lordship call for a report from the state. Petitioner is in custody for 3 years, 3 months. Page 17, your lordship directed the trial court, page 17, to arrange for production of co-accused through video linkage.
Yes, well, that has been done. Subsequently, in the month of January, charges have been framed.
And only 2.5 witness was examined.
2.5
My lord,
witnesses.
page 8, paragraph 7, 2 witness, my lord, full, and 1 witness, my lord, chief only.
How long you are in custody?
I am in custody for 3 years, 3 months.
Now, my lord, would kindly come to page 5 of the report, my lord. The learned public prosecutor conducting the trial, he has given an intimation that although there are 48 witnesses, they will be examining 34 maximum, and a time frame he has taken 10 to 12 months. Because, my lord, the bulk of the delay was post the framing of charge, pre-framing of charge, and thereafter, my lord.
All right. He's already 3 years, 3.5 years. That's half of these.
But my lord would also kindly come to page 4 once, my lord, the cases that are pending in all the states.
All right.
Similar cases are pending.
Petitioner contends that he is in custody for 3 years and 3 months. There is a possibility of trial concluding in near future. He prays for bail on the ground of delay. Learned lawyer for state submits report. He contends petitioner is a member of an organized gang which carries organized gang of dacoits who have criminal cases in various states.
Yes.
In various states, who are facing criminal cases in various states. As a result, the co-accused could not be produced, and there was some delay. Thereafter, co-accused have been produced via video linkage and trial commenced.
Yes.
He proposes that the trial, the report proposes the trial shall be effort shall be made to conclude the trial within a
10
year.
to 12 months.
Within a year.
Yes.
We have considered the materials on record. There are ample materials implicating the petitioner in the offense of dacoity. He has criminal antecedents. Other accused also have criminal antecedents and are facing trial in different parts of the country. On the intervention of this court, the bail prayer of petitioner was rejected earlier.
Thrice.
And pursuant to intervention by this court, co-accused have been produced via video linkage and trial commenced. Prosecution proposes to conclude the trial within 10/12 months. There is, in the event petitioner is released on bail, there is every possibility that he shall abscond. Under such circumstances, we are not inclined to grant bail. However, we direct the trial court to conduct trial by fixing schedules at short intervals and examine with short interval, ensure attendance of the accused either personally or via video linkage, and conclude the trial preferably within 1 year from the next date fixed for recording evidence. No unnecessary adjournment shall without granting unnecessary. Next.
Wait, please, Your Lordship. I am appearing for the petitioner. My lord, this is a renewal of my prayer after 1 year, 3 months.
কিসে পাঠাবেন?
Your Lord. Yesterday, there was a prayer for adjournment.
Other cases are to be tagged with this case. No.
There is a single sole accused.
No. With Tariq, we are giving bail to them. Petitioner is in custody
For 1 year, 7 months.
1 year, 7 months.
Two eyewitness on 12th.
Well, that is
He
not.
said 12th is the date for two eyewitnesses,
Another 2 eyewitnesses.
from whose shop he has
chopper.
taken the chopper and assaulted the victim.
All
What he
right.
said.
1 year, 7 months. There is inordinate delay in trial. He prays for bail. Learned lawyer for the state opposes the bail prayer. Learned lawyer and submit. Date has been fixed for recording witnesses.
On 12th November.
Recording evidence on 12th of
This month.
This month,
oh 12th.
12th November. They are the last two eyewitnesses.
Two eyewitnesses, Your Lordship, and they are the employee of the shop.
13th we are keeping.
Very. My lord, only the witnesses are not appearing. That's why.
No, they have
We
appeared.
will do like this.
That's why.
12th.
Yes.
In view of the aforesaid submission, we adjourn the hearing of the case till 13th. Witnesses shall be positively produced on the said day, examined and discharged.
Can it be on 15th, Lordship?
15th is a holiday.
Holiday.
12th is the last chance you get your witness examined, irrespective of his work, etc.
Marriage.
Right.
Huh?
Marriage is there.
Marriage for witness.
No,
My lord, out of 25, 9 has been examined as of now. He says there are.
These two are the only eyewitnesses left, from whose shop he has taken the
Very
chopper.
well. Let it be on the 13th.
No, other eyewitness, the relation is there, injured witness evidence is already there.
yes.
What is
No,
there?
they have identified him.
Then we are giving you one chance. If you can, very good. Otherwise, we
Only Lordship, only if they can be on 15th, Lordship.
15th is a holiday.
Good Friday.
Good Friday.
Good Friday.
Guru Nanak's birthday.
Any Friday is Good Friday.
Then Lordship, then 18th, Lordship.
Not with here.
All right. Grateful. Lordship. 13.
हाँ बिल्कुल
ये मामला में मिलने से ही आपको वेरीफाई कर दो।
अब से पहले
In exceptions, I am mentioning one matter, my lord, seeking leave to file without the GR number. I have annexed the GR number.
No.
Anticipatory bill.
Why not?
I have,
Why you will not get the GR number?
it was filed, my lord, without GR, it has been returned.
You were rightly returned.
My lord, I will, I kindly grant you shall, my lord.
Zero, absolutely no leverage. All the list.
Yes, your lordship, please. I have already contacted.
Item 70. Yes. Your Lordship, the allegation against the petitioner is under section 341, 325, 307, 385, 34 of the Indian
If
Penal
your
Code.
extortion is why we will give you bail.
The main co-accused who was involved in firing was enlarged on bail within 22 days, Your Lordship, by the learned lower court. We preferred an application for anticipatory bail thereafter before the learned district judge Howrah, thereafter High Court, thereafter I voluntarily surrender before the learned court below. Till date, I'm 82 days in custody, Your Lordship. The other co-accused?
Yes. Who is first state?
Lordship, praying for short pass over. Actually, Mr. Subhamay Bhattacharya is appearing.
Huh?
Mr. Subhamay Bhattacharya
Yeah, but where is the case diary?
Actually, case diary is with you.
Not today, not today.
My lord, may I mention one matter, my lord?
No.
My lord, item number 14, my lord, your
Oh,
lordship.
sir. Call the list.
76. My lord, I am for the petitioner 76, my lord. My lord, I am in custody. I am in custody for 308 days. The charges of section 302 and 34, my lord. My lord, according to the FIR, my lord, the victim was called by 8 persons, and thereafter, 1 day later, his body was recovered. My lord, these 8 persons were named in the FIR, but my name did not transfer in the FIR. Subsequently,
My lord, the name appeared, my lord. He is one of the accomplices.
subsequently in the charge sheet, my lord, out of those 8, my lord, 6 has been discharged. 5 have been discharged.
Case 214, my lord.
Yes. In addition to this, what is there?
No, my lord, nothing. This is
No recovery. No incriminating material was recovered.
No, my lord.
Lordship, may I humbly submit one thing? I'm from the de facto complainant. Initially, the de facto complainant lodged FIR against 8 accused persons. Out of them, 5 accused persons were not charge sheeted. After that, there was a development that new 5 names were incorporated. Challenging that charge sheet, they filed an RG petition before the learned court below. However, just before the vacation, it has been rejected. Now we are in a position to prefer an revisional application, Lordship. There is one fact: this petitioner was not named in the FIR, but 6 accused persons, those who were actually not
He
charged.
released on bail, apart from one statement that he was standing.
I leave it up to your Lordship. Just a submission from our end that this happened actually.
Petitioner is in custody for
308 days.
308 days. He contends he was not named in. He contends he was not named in the first information report. Accused who were named in the report have been, most of the accused who have been named in the report have been discharged. He has been falsely implicated. He prays for bail. Learned lawyer for the state opposes the bail prayer. Learned lawyer for the de facto complainant submits that he has challenged the discharge of the FIR named accused persons. We have considered the materials on record, save and except one statement showing that petitioner and two others were standing in the field where the murder had been committed. There is no other incriminating material involving the petitioner in the crime. In view of the aforesaid, in view of the slender material on record, we are inclined to enlarge the petitioner on bail subject to condition, meet investigating officer once in a week and further.
As calculated, custody will be 330 days.
330 days. Next.
Four 320, 307, my lord. My lord, 5 years of marriage, my lord. The husband, petitioner is the husband, my lord. There is a misunderstanding, my lord. The mother-in-law filed this case, my lord. Paragraph 7, my lord, they are living together now.
Poison was forcibly poured down her throat. She was hospitalized for 3 days. This is the declaration which was taken by the doctor while she was in a critical condition. It squarely implicates all the accused persons. And
We have considered the material.
Paragraph 7, my lord. Paragraph 7, my lord, kindly see they are living together now.
Living together, my lord, defect is present, my lord.
Factor is present.
My lord,
Then
de facto is the mother.
Mother, my lord.
De facto is the mother of the victim.
where is the victim? Let the victim make a statement before the magistrate.
Initially, the case started under bailable section 323, then 307, then 302. My lord, kindly have a look into the paragraph 5. My lord, that is why, my lord, it was a case of 323. My lord, the
Handicapped person was murdered, my lord. He is the principal accused, my lord. Kindly see the 164 statement, my lord. One of the accused is still absconding, my lord.
my lord, my son and me both are in custody. My lord, it was a ambulance faced an accident. My lord, that is why it was a case of 323 because the
statement ये तो मारा गया
They are saying assaulted with
yes, my lord. Kindly see the primary health centers, my lord, report. My lord, there, my lord, it was a very simple.
medical report.
Medical, my
That is simple. Then, my lord, on the way to hospital, my lord, the
Once again.
ambulance.
PhD of Arambaka medical page,
48 to 52. 52.
52 and my lord NRS, my lord.
He was discharged.
Yes, my lord. Discharged then while
Hospital
well, no, at Bardhaman, while Bardhaman going to the Bardhaman, the ambulance, my lord, faced with an accident. My lord, I have given the number of the ambulance.
No,
My
no,
lord,
my lord, kindly see the reason of death, my lord. Post-mortem.
my lord, sir, preliminary injury, my lord, kindly see. Now, my lord, 159 days I am in custody.
Page 38, my lord.
And later, it was alleged that my son assaulted. He also made accused later on. In the FIR, being eyewitness, the de facto complaint says it was me. Then, my lord, some eyewitness said my son.
No, he is eating. I was just no, he was eating. This is the trauma overhead and forehead due to alleged physical assault.
Page 38 also.
Petitioner contends that the victim suffered injury due to road traffic accident. He prays for anxiety bail and a lawyer for the state opposes the prayer. We have considered the materials on record. Medical report shows that the injuries were due to physical assault. Statements implicate the petitioner in the crime. Under such circumstances, we are not inclined to grant it. That's all. I was just seeing whether he was discharged from hospital. Thereafter, he has died. So,
আমি কাগজ দিয়েছি কাগজ দিলাম এটা কাগজ দিয়েছি
first reading. Next.
My lord, yes, under section 302, 201, based on circumstantial evidence. The present petitioner before your lordship is the owner cum driver of a car. What happened, my lord? One Nasiruddin and my lord Shahjahan, and along with the wife of the Nasiruddin, they hired this car from 24 Parganas and went to Howrah. Thereafter, they went to a place. After some time, they came and they boarded in my car. I came back and returned them in Southeast One. But at that time, the wife was not there. Subsequently, my lord, body was recovered of the wife of the body recovered, and my car was there, my lord. The nameplate of the number plate of my car was there. It is CCTV footage, my lord. Yes. It will appear from the CCTV footage that there is a picture of vehicle, my lord. Yes, I admit. He is one of the co-actors, my lord. He was
So
also involved. directly involved.
He says
No.
he is the vehicle owner.
Owner cum driver. He was on the spot, my lord.
Then petitioner was the owner of the
vehicle. The box was taken to the pond and it was dumped there. Local shop owners CCTV camera shows that the vehicle is coming out from that area. Subsequent to that, the photographs are there for the next toll plaza out.
Yeah. His vehicle was used to take the victim and the husband to the spot. Then the husband comes and goes.
But from the dead body was
But the murder, where the murder took place? Where did the inside the car or
Inside the car, it was CCTV footage of a factory, my lord, intercept my car. My lord, the body was found from a pond.
So they say that from the factory to the pond, your vehicle is being used to carry the.
No, my lord, so far subject to lordship kind sanction. I have gone
examination of
charge
the
sheet, my
vehicle.
lord. Charge sheet I have not found, my lord. Subject to lordship kind sanction.
Forget your charge sheet. What you have. Let us see what- The charge if framed like that is a recipe for an acquittal. All right. So please address where it is relevant. The argument is that he is a hired vehicle. He did not know about the act of murder. The show us where the involvement of this person is beyond innocent carriage. Right? That He says what? The man and the lady had hired my vehicle. They went to a factory. Then the man left.
That is not a statement neither in this petition nor in his statement under 160. He is saying that I have a car which I had given it on rent and it was being driven by somebody else.
No, but what is your case? What is your?
He was there in the car.
Very good.
Well, kindly see page. I know this will not be admissible now. ওটা তো আপনি হাতে ধরে বসে আছেন। ওটা কি দেবো? কাকে যতটা কি দেখতে বলবো? মৃত্যুঞ্জয় petitioner?
104. The body was recovered from this.
চালা দেখতে পেলে বডি পড়ে আছে দুজন যাওয়ার পর একজন ক্লিয়ার এটা এটা কে বলেছে চার্জশিটে তো করে আছে স্টেটমেন্ট গুলো
Come up that we had let this vehicle.
That is not I drive the car. Statement দেখলে বোঝে এখানে গাড়ি ঢুকতে পারে না যেখানে বডি পড়ে আছে এখানে ঢুকতে পারে গাড়ি কোনো বাইরে রাস্তাতে ছাড় জঙ্গলে সমস্ত গাড়ি ঢুকবে রাস্তার মধ্যে গাড়ি ছিল ওরা ভিতরে ঢুকেছে পাওয়া গেছে ভিতরে জায়গা থেকে কাশি দেখে জঙ্গলের ছবি একটা এখানে রাস্তা কোথায় এখান থেকে এত দূরে বডি পেয়েছে ছবিটা খুব সুন্দর গেছে আমি গাড়ি থেকে নেমেছি এটা তো চার্জশিটে কোথাও বলছে না সিসিটিভিতে ওই ফ্যাক্টরির সিসিটিভিতে আমার গাড়িটা দেখা গেছে আমি তো ছিলাম আমার গাড়ি তো ছিলই এটা তো অস্বীকার করার জায়গা নেই আরে গাড়ি তো আমি চালাচ্ছিলাম হ্যাঁ
আপনার সিসিটিভি ফুটেজ ছাড়া তো আপনার মনে হয়
Kindly consider the forensic report, my lord.
Vehicle was used for transportation of the corpse.
Vehicle was used.
And he was the driver.
Whether he was present or not, that he is saying.
He is also saying, I am the driver.
He is saying where? In his
Before your
161
lordship
statement before police.
Before your lordship also. This is within his knowledge, special knowledge, whether he had let it on hire or allowed his friends to drive that vehicle.
So these are just pen drives.
Yes, madam. I have asked for the original sequel of the lawsuit.
And no, so far the charge sheet, my lord, no FSL report.
Also, the vehicle was seen.
Huh?
Yes.
Immediately thereafter, while fleeing away, the nearest.
One thing is sure, that his vehicle is being used for a crime. Whether that was an innocent hired or not, that is to be. How long you are in
My
custody?
lord, 270 days about, my lord.
Petitioner is in custody for 270 days. He submits that the co-accused had taken his vehicle on hire and he had no knowledge of the commission of the crime. He has been falsely implicated. He prays for bail, and a lawyer, a learned public prosecutor with Mr. Rai opposed the bail prayer. They content CCTV footage shows the vehicle was used for commission of the crime and disposal of the dead body. We have considered the materials on record. CCTV footage shows the present CCTV footage and other materials prima facie show the vehicle of the petitioner was used to commit the crime. Whether he had requisite knowledge with regard, whether he was present at the spot or had whether he had requisite knowledge with regard to the offense is unclear. Is unclear, and request to be established in during trial. Under such circumstances, he did not have motive to commit the crime. No monetary transaction between himself, motive to commit the crime. In keeping in mind the extent of complicity of the petitioner, and as the investigation is complete and there is no chance of abscondence, we are inclined to enlarge the petitioner on
Grateful, my lord.
him on bail.
ACJ Muluberia, Howrah. Deeply obliged, my lord. The case is by the 304.
Bar Council? When is your election, Bar Council?
Not before 26.
Not before 26.
81.
Under this case, my lord, I have gone through the case that it appears it is accidental death by train.
Accidental death by train. What?
That's why that's through train.
What was the lady doing on the train track?
I don't know, my lord. This is
Drying cow dung.
Not cow dung.
Huh?
Because that is
Committed suicide,
I
definitely.
have gone to the statement here is
Accidental death by train. What was she doing on the train track?
In fact, is appears on the case that he was passing.
Huh?
Dead body was found.
Naturally.
Maybe suicide. Maybe. Maybe or maybe not. Yes, my lord.
Maybe or maybe not. If it is maybe, then 304B, you demanded rowdy. Out of torture, she went to the railway track and committed
My
suicide.
respectful submission is that I am in custody, my lord, 156 days, and I am the brother-in-law, my lord, not the husband. Husband also is in custody. And I
How
am
many
totally
years
separate.
after marriage incident occurred? 1 year.
1 year, 5 months.
Then
I totally separate. I am
what totally separate?
Separated from the resident. I am not involved, not connected with the family, my lord. With the
You
family.
stay in the same house.
No, they are saying, my lord, my lord, it is a complaint. When the complaint has
In
been
the cost title also DTPS pipeline
no,
lane.
separate, my lord, separate.
Same basti you stay.
Basti, my lord, separate, my lord, this basti, one house, my lord, another house, my lord. And I have not connected, not involved in this matter, my lord. So in my lord, dead body is found immediately, my lord, from got from something.
Specific allegation.
Where is the case
I
diary?
have not specific allegation.
When it comes to the first statement, the 43 action.
She's sleeping on the bed. Accidentally.
Actually, this is was going to his paternal house, my
Going to the paternal house, walking down the railway track.
Yeah, my lord.
Huh?
Most probably, my lord, not properly. So, my lord, this
What not properly?
properly not going, my lord. My lord, this is not the.
When is the last accident which occurred at that site?
No, what actually happened is, and brother-in-law, well, I mean, maybe 156 days. 150 days.
See the page 9, the complaint lordship. Page 9. Page 9 complaint. Thereafter, I've shown you the page number. Yes. And on the 36, you see.
What is your name? Sanjay.
That is his statement for the policeman. Choton Bera is 39. Another brother.
Petitioner is the brother-in-law of the victim lady. It is submitted he did not play any role in the matrimonial life of the victim. Victim suffered unnatural death on the railway tracks. He prays for bail. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Allegations against petitioner is the brother-in-law of the victim lady. Allegations against him are general and omnibus. Investigation is complete. There is no chance of abscondence. Accordingly, we are inclined to enlarge him on bail. Statement है, इसके खिलाफ में कोई allegation नहीं. Next.
But I am appearing on behalf of the petitioner.
State का interest है इसके बिल पर. Take a lead.
One employee of the de facto complaint company, my lord, had committed theft of rupees 18 lakh during the cash transfer, my lord, from the van itself. Actually, he is the gunman of the van, my lord. My lord, a 17 lakhs rupees were recovered from such person and from his wife. I am neither the employee or not any other person.
403,
my lord.
316.4 and 316.5, 407, 408.
8 and 9, my lord.
This petitioner.
408 and 9.
408
and 9. my lord.
No, clerk or servant.
Clerk or
9 is public servant. You are not a public servant.
No, man.
How much is the misappropriated amount?
18 lakhs, was 17 lakhs recovered, 1 lakh.
Then petitioner submits, he is in custody.
150 days, my lord.
150 days. Most
120 days, man.
120 days. Most of the misappropriated sum has already been recovered. Further detention is not necessary. Accordingly, he may be enlarged on.
Grateful.
He's not the main accused.
No.
CJM Purbo Medipur.
Next.
83. No, I am for the petitioner. This petitioner is in custody for about 5 years, 10 months. 395, 397, my lord. Now, out of 18 witnesses, 12 have been
Petitioner is in
examined.
custody for more than 5 years. Trial has not come to an end.
So the next date is on 12th. So it's a last schedule. 13, 14, and
Prosecution
15.
proposes to examine 3 more witnesses. Offense, even if proved, would not attract mandatory life imprisonment. Under such circumstances, we are inclined to grant bail subject to strict condition. Petitioner, while on bail, shall remain within within Pandua police station, except for attending court proceeding and report to officer in charge Pandua once in a week.
I'm grateful.
Deeply.
Next.
CJM Kalna. Additional season.
I'm renewing my.
That's a part of the interview board with just Two.
Renewing my prayer after 14 months. In the meanwhile, my lord, 8% has been examined. No one of them named me. My lord, these are the depositions. 38 to be examined. My lord, case of circumstantial evidence.
Who are these may not be. Who are the persons who are saw you coming out of the
My
field?
lord, all are the person 8% who have been examined. They were claimed that they are the after my lord, immediately after the incident they reached there. No one claimed my presence. No one named me.
Sir, we want to know there is a circumstance that witnesses saw you coming out of the field with a blood-stained Heshua.
Yes, my lord.
Who are these witnesses?
My lord, these eight witnesses. No one named me. Only the recovery, my lord, by the police to my leading statement. That was the evidence. That is why your lordship was pleased to reject my prayer. My lord, except that the person who are the immediately after the incident who came, they are these 8 persons. These 8 persons, no one named me.
These 8 persons named you.
No one named me.
In the statement before the police.
Yes. These persons named me. Now they have said that they have.
But they have not been declared hostile.
My lord, petitioner number 1 and 2 has been declared hostile. Other, my lord.
Why?
My lord, because they said I don't know about the incident. My lord, other.
They may not know about the incident. If their previous statement implicated you, they should be declared hostile. And even PW1 is not declared hostile. Where is it declared hostile?
My lord, the PW1 is the last 2 pages. My lord, he was declared hostile.
We do not see.
My lord, this is my copy.
So you give us only PW3.
No, my lord, they all witness. PW at the back, the PW1 is
here. That is PW8.
Yes, no, PW1, my lord, this page.
It's not there.
Yes, my lord, with your lordship's copy also.
রঞ্জিত সর্দার,
শম্ভু রয়, সুখেন দে, রাকিবুল ইসলাম, সেলিম শেখ, প্রভাস সাহা, আর খগেন্দ্রনাথ রয় and de facto complainant himself.
Mr. Roy,
kindly page 98, 103, 106 and 108 ওর কাছে থাকলে জজ সাহেব দেখবে কি করে? কেস ডায়েরিটা তুলে দিস না। None of them have been as yet examined. I've just checked from my learning. 98. Previously also you wanted to assault somebody. The prosecution, what has been gathered during the course of the investigation, that he was passing through a bad time. He had on that date only sacrificed 2 PGMs. Thereafter got hold of this and sacrificed him also.
$98.
103. Sushil Rai.
Sushil Rai has been included.
Mukul Boisho.
Filter diploma.
মুশকিল তোরা দেখে কেউ বলবি না 4 থেকে আগে এক্সাম না করে 34টা 38টা থাকবে বেলটা রিজেক্ট হয়ে গেলে বিল করবে আর ওটাকে তো দেখি জিজ্ঞেস করবি 38টা থাকবে এই 4 থেকে আগে এক্সামিন করে ওটাকে সিরিয়াল লিস্টকে নিয়ে এক্সামিন তাই তো
এরা সবাই বলছে যে আমরা ওখানে গেলাম ইমিডিয়েটলি শম্ভু রয় আছে সুখেন দে রফিকুল ইসলাম সেলিম শেখ প্রভাস সাহা
Sushil Roy has not been examined.
Yes, my lord.
Has been examined?
No, Sukhen they have been.
No. What is Sushil Rai?
Sukhen they have
106. Mukul Boisho, not examined as yet.
সেলিম তো হয়েছে, সুশীল তো নেই এখানে, 8 জনের মধ্যে সুশীল না। খগেন্দ্রনাথ রয় হয়েছে,
সুশীল রায়, মুকুল বৈশ্য।
নেই ফ্যামিলি বালা mostly 164.
রাশিকটা দিবি তো আমার, ঠিক বুঝবো কি করে?
Petitioner submits that 8 witnesses have been examined and they have not implicated him in the crime. He renews his bail prayer. Learned public prosecutor opposes the bail prayer and contends vital witnesses, namely Sushil Rai, Mukul Boisho, Shamoli Bala Roy, and others have not been examined as yet. We have considered the materials on record, including the statements of the said witnesses, which prima facie implicate who state that they had seen the petitioner come out with a bloodstained hasua from the maize field where the victim was beheaded. In light of as the most vital witnesses have not been examined, we are not inclined to, and the gravity of offense, we are not inclined to grant bail at this stage. Roy, please help us. All right. It is not how many days and what section. Each case is independent. Next.
My lord, 302 case is based on circumstantial evidence. Now, my lord, in this case, my lord, 164 statements were recorded. Now, my lord, one Bablu Sheikh and one son of the complainant and another person who is a laborer who was present near the spot. Now, my lord, Bablu Sheikh categorically stated in 164 that, my lord, he has seen the 2 person who fired the shot to the deceased Muslim, and my lord, he can identify those 2 persons. Now, my lord, TI parade has been done. Bablu Sheikh identified 2 persons, namely Tubai Ghosh and Ujjwal Mondol. Now, my lord, subsequently, another 12 persons has been roped in this case due to political fraction. We have also annexed another my lord, counter case against the deceased, who was a notorious criminal. And now, my lord, 23 witnesses in total. My lord, till date, only charge sheet submitted. I am in custody for 5 months.
164 statements, my lord. Lord, are at page 146, 147.
What is Nazim Sul?
Independent witnesses statement. Lord, at page 307, 308. It's a 161 statement at 307, 28.
Petitioner submits that he has been falsely implicated out of suspicion in the FIR, as well as statement of witnesses recorded under 164 CRPC. It was stated 2 persons were involved in the murder of the deceased. Who identified Bablu Sheikh?
Bablu Sheikh.
Bablu Sheikh, a witness, identified
one Tubai Ghosh and Ujjwal Mondol.
One Tubai Ghosh and Ujjwal Mondol as the assailants in the TI parade examination. Petitioner is in custody for
5 months.
5 months. He prays for bail, and a lawyer for the state opposed the bail prayer. We have considered the materials on record in the FIR. It is alleged. It is alleged 2 unknown persons killed the victim. The complainant suspected the involvement of the petitioner in the murder. Witness Bablu Sheikh identified so and so and so and so as the said assailants during TI parade examination. Involvement of the petitioner is based on suspicion. There is no direct evidence that he was implicated, that he involved in the murder. He is in custody for 5 months. Investigation is complete. Accordingly, we are inclined to grant bail.
Kindly restrict the entering of this within the PS chapter.
Not to enter chapter police station.
I'm for the brief.
Genuine.
Your lordship have passed certain directions with regard to under trial prisoners and terminally ill. This petitioner false has been categorized.
But page 12 is the order of your lordship, my lord. I have found, my lord, in the petition, wherein, my lord, a list was, my lord, submitted before your lordship at the time of hearing. My lord, the list in that page 60, he is in serial number 4. Five.
How long you are in custody?
7 years.
Petitioner is in custody for over 7 years. He is suffering from, as per report submitted before this court in WP in so and so. It appears that petitioner is suffering from serious illness purely on medical grounds. Petitioner is enlarged on bail.
ACGM Paruju.
All the cases.
ACGM Paruju. লিখে দিচ্ছি. Great.
Next.
It is a case based on circumstantial evidence. My lord, I am in custody for almost 2 years. Now, my lord, the circumstance is that, my lord, statement of a co-accused person. The allegation is, my lord, one Muslima, my lord, she
Yes.
lodges a complaint.
Yes, yes, yes.
Can you see the statement of the daughter of the deceased? 164 statement.
What is the circumstance against him?
There is no recovery from him.
For statement, he is the daughter is the eyewitness. My lord, at the time of incident, this petitioner and wife of the deceased has a illicit relation, and out of a conspiracy,
My lord, she
they
can.
murdered the victim.
Petitioner submits that he is no way involved in the crime. He has been falsely implicated out of suspicion. He pays for bail. Learned lawyer for the state submit. Petitioner is the paramour of the wife of the deceased. They hatched a conspiracy and murdered him. We have considered the materials on record. Daughter of the couple deposed that petitioner and her mother collaborated to collaborated and administered sleeping medicine,
Strangulation.
sleeping medicine to the deceased. Thereafter, he was strangulated to death. Petitioner was present in the house on that night under such circumstances, in view of the aforesaid incriminating material. And
Kindly
captive
seize the
offense,
FIR for a moment.
we are
The
not
daughter, my lord, first goes to the SDO saying that my father is missing for the last 4 days. But she could not have been an eyewitness to it.
That's what she says.
Oh, আরেকটা মেয়ে আছে?
তুমি দীপক যোশী বলে তলায় নাম্বার ব্যাস নেক্সট
I am for the petitioner, my lord. The allegation is under section 302 of Indian Penal Code. The petitioner is the father of the deceased.
Mother murdered son.
Lord.
There is a statement of 164 statement of the wife of the deceased and the 161 of the mother.
let us see one.
Kindly see the 164 of the complainant mother at page 23-24, my lord, and the mother at page 5.
My lord, the petitioner is in custody for, my lord, more than 4 years, my lord. 4 years, 5 months. 4 years, my lord.
Why did he do it?
My lord, the deceased used to torture his parents, my lord, every night after drinking alcohol, my lord.
No, my
I am in custody for, my lord, almost, my lord, 5 years, my lord. 4 years, 5 months.
statement of the brother is also there, the son of the accused, my lord, at page 4.
We have considered the materials on record, heard and considered materials on record, statements of witnesses, that is mother and wife of the deceased show petitioner, that is his father, had assaulted him with a sharp cutting, resulting in his death. Under such circumstance,
My lord,
Yeah,
may I humbly submit one thing, my lord? Trial has not been started, my lord.
Next, trial be expedited. Next.
Well, this lady went to a bank to deposit a sum of rupees 10,000. Subsequently, at bank, it was found to be fake Indian currency.
10,000.
Well, this lady went to bank to deposit.
10,000 you are depositing.
On the same day, my lord, the husband of the accused before your lordship was been arrested by the SP of Kolkata on the same day.
All right. Petitioner submits that she had gone to the bank to deposit currency, believing the same to be genuine. Accordingly, she prays for bail. And a lawyer for the state submit. Petitioner and her husband are involved in dealing in fake currency. Her husband was arrested in another case involving fake currency. We have considered the materials on record. Petitioner had gone to deposit. We have considered the materials on record. Husband of the petitioner was apprehended with fake currency notes. A separate case was registered. On the same day, petitioner went to deposit a large volume of currency to the bank, which was found to be fake. In view of the aforesaid materials, it appears that petitioner and her husband are involved in dealing in fake currency notes. Keeping in mind the nature of the gravity of the offense, we are not inclined to grant bail at this stage. Okay, that has been good. Okay. Thank you.
May please, your lordship, my lord, the principal section is 302. What happened, my lord? A fire against 41 person, my lord. It is said that after a meeting, my lord, the one of the political parties, one of leader or my lord, the cadre was coming. That time, my lord, 41 person, my lord, assembled there, and they have assaulted him, and subsequently he died, my lord, and dead body was recovered. Charge sheet filed. 21% has been discharged from charge sheet. 20% against 20 charge sheet has been filed. My lord, so far the charge sheet is concerned, I was taken into custody.
41% were in the FIR. 20 have been discharged. 21 have been charge sheeted.
20 has been charge sheeted. 10 are absconding out of 20.
We are not on 10 absconding. 21 have been discharged. What is the difference between these 21 who have been?
Basically, the name of this petitioner has come under section 164.
So,
he along with others, but they are kindly said this 164.
petitioner is
The postmortem report, your
in
lordship.
none of the 164 the others name appear. In none of the 164 the other discharged accused name appear.
No, their names are not appearing.
They are appearing in the 161 statements.
160. 161, their names are not appearing. Most of the 161.
Yes, some of the 161 they are.
But 22 injuries are there, lacerated injuries, sharp cutting injuries. But it has been done with common intention by all these.
Correct. We are suspecting that the common intention was shared also by the discharged accused. And since you are picking and choosing accused, we will enlarge them. Petitioners are in custody for
166 days.
166 days. It is contended. FIR was registered against 21 accused persons. 20 of them have been discharged.
21, my lord.
21 have been discharged, and charge sheet was filed against 20, including petitioner. The allegation leveled against the petitioner, accordingly, petitioner prays for bail. Learn a lawyer for state submit name of the petitioner. Name of the petitioner has transpired from statement of witness before magistrate. We have considered the materials on record. We have examined the statement of the witnesses before police as well as magistrate. Some of the witnesses named the discharged accused before police. Allegation, however, discharged accused before police. No explanation is, no cogent explanation is forthcoming why, why they were discharged. Why they were discharged. It appears that the investigating agency has picked and chosen accused for prosecution. It is also relevant to note that the allegation against the petitioner is generic in nature, no specific generic in nature. There is no chance of abscondence. Accordingly, we are inclined to enlarge him on bail.
Grateful. ACGM Holdia.
Statement report means shift and purposes to shift so that this meeting out of false case can be
This is a case where I'm claiming parity. If your lordship kindly turns to page 15 once, one of the principal accused who happens to be the gold appraiser has been named in the FIR, has already been granted bail. We are the bona fide loanees. My lord was pleased to grant bail at least to 76%. I am standing on the same footing.
Petitioner is in custody for
122 days.
122 days. Hey, page 17. Allow.
My lord, 118 is the same matter. This Tharia Hussain is there.
How long you are in custody?
My lord, in 183, I am in custody 44 days, sir.
100?
118.
118. Let it be called.
The number of days in custody is 44 in this case.
Let it.
My lord, let it be called.
93, my lord. The 93 is 89 days, my lord.
89 days. We are granting it. Others have been granted bail.
My lord, but they had, my lord, submitted fake ornaments, my lord, to take the loan, my lord.
Ah.
My lord,
All of
and-
them have been
yes.
granted.
Same.
89 days. You said 100 and...
No, 118 and 93 are same matter.
No. How many days they are in custody?
My lord, I am in custody for...
89
My lord, I was arrested on 7th of July 2024. Means I am in custody for 122 days.
122 days. Madam, in your case, it is 122 days.
My lord. Got it right, though. My lord, 120 days.
So we are granting bail in 94. We'll consider when we come to 108.
193. This is item number 93.
Right.
And 118.
We will come.
My lord, my lord.
94. 94. Right.
Dispute regarding a throwing of guard. Allegation under 341, 326, 307. There is dispute regarding throwing of garbage between two own brother, my lord. 145 days custody.
Petitioner is in custody for 145 days.
Custody submitted.
Investigation is complete. There is no possibility of trial concluding in near future. There is no chance of abscondence. Under such circumstances, we are inclined to grant bail.
Get full.
Next.
ACGM Chandana. ACGM Chandana.
Get full.
For the petitioner, my lord, on 11th September 2024, your lordship allowed prayer for bail of the co-accused person, namely Sujauddin Sheikh, who is on the same footing.
Page.
Exactly.
Page 11.
11. Page number 11. I have annexed the order sheet.
I'm for the defective complaint.
No overt act against petitioner.
Imran Sheikh fired from gun.
You are Jiarul Sheikh. We have considered the materials on record. No specific overt act is attributed to the petitioner. Under similar circumstances, Shujauddin Sheikh has been enlarged on bail. We are inclined to extend the same privilege to the petitioner also.
Your lordship, there is in 164 statement.
Yes, we have seen it.
I'm good.
Next.
This is a case of murder. Petitioner is in custody for 7 years, 6 months. Well, out of 25 witnesses,
Petitioner is in custody for 7 years, 6 months. He prays for bail on the ground of delay. State shall submit report with regard to status of proceeding and reason for delay. 1 week. Next.
I'm for the petitioner. My lord, petitioner is in custody for a period of, my lord, more than 2 years, 3 months, my lord. My lord, the allegation are, my lord, 489B, 489C, my lord. From the position
of 500.
My lord, kindly see page 28, my lord.
Your lordship rejected it earlier for 2 times.
Rejected the trial court to conclude the trial within a period of, my lord, 6 months, my lord. Out
Petitioner
of
is in
10
custody for over 2 years. There is slow progress in trial. He renews his bail prayer and a lawyer for the state opposes the bail prayer. We have considered the materials in record, though allegations are grave. We note that petitioner has suffered detention, under trial detention for a considerable period of time. How many witnesses examined?
10, my lord. Only 2 examined, my lord.
Only 2 out of 10 witnesses. 3 out of 10 witnesses have been examined. There is little possibility of the trial concluding in near future. Under such circumstances, we are inclined to enlarge the petitioner on bail.
Yes.
Next.
My lord, I'm appearing for the petitioner. My lord, I'm praying
Lordship, I am for the petitioner. Lordship, it's a case of murder. Lordship, I'm renewing my prayer for bail. And Lordship, out of 30 witnesses, 4 has been examined. Amongst the 4, 1 is the eyewitness. And Lordship, she specifically stated few persons' name, but my name has not been stated by any of the witnesses.
All right,
Lordship, I
let the
only have the
trial go on.
Xerox copy of
The
deposition.
petitioner contends that one of the eyewitnesses have not named him. He renews his bail prayer. Learned lawyer for the state submit. There are other eyewitnesses who are yet to be examined. We have considered the materials on record. Bail prayer of petitioner was rejected earlier on merits. Though one of the eyewitnesses has not named the petitioner, there are other eyewitnesses who has named him in their statements before police. They are yet to be examined. Given this situation, we are of the opinion it may not be prudent to release petitioner on bail at this stage.
Grateful.
Next.
My lord, I am for the petitioner, my lord.
People are also speaking.
My lord, no fake currency recovered from my possession, my lord. Based on the statement of co-accused, my lord, I have been implicated.
We have considered the materials on record. No fake Indian currency notes was recovered from the petitioner. He is in custody for
127 days.
127 days. Investigation is complete. Accordingly, we are inclined to grant bail.
Grateful.
Next.
Can it be placed before the regular bench? Due to my mistake, it was.
So why you mention?
But my own mistake.
For excitement, you mention everything and then regular bench. Regular bench.
Grateful. Regular.
देखता है कितना बिल दे
105 টা regular bench on. ওই দিছি my lord, I am petitioner, my lord. Well, this is case of my lord, circumstantial evidence, my lord. I am the sister-in-law of the deceased, my lord.
26 नहीं तो
Well, circumstantial evidence, my lord. I am the sister-in-law of the deceased, my lord. My lord.
Rape, murder and dacoity.
No, robbery. My lord, suddenly, my lord, accidental, my lord, burn injury, my lord.
What is 326G? That is robbery or housebreaking.
My lord, they try to attempt, my lord, throw the
We
fire
are
on
asking you what are the offenses first. One is murder, then 326G. Mischief. Mischief by fire. Yes. How many people died?
My lord, 3 persons died, my lord. My lord, one. My lord,
We have considered the materials
lord,
on
one thing,
record.
my lord.
Explosive substances were illegally stored,
My lord,
resulted in a.
My lord, FSL was.
The petitioner had an affair with that woman. The deceased, the male deceased. There are 3 deceased: husband, wife, and the minor child. One of the minor child survived.
They set fire in the house.
Fire.
That is what we are saying.
Chloroform, then set fire by
My lord, one thing, my lord.
Not,
Must go through the my lord, FSL, my lord, the container which is recovered, my lord, that my lord not matching with the my lord, the FSL, my lord. There is no my lord petroleum anything, my lord. I must go through CFSL, my lord. report.
Petitioner contends that he has been falsely implicated. Forensic report does not show that the seized container had stored was used to store inflammatory material which was used inflammatory material. Accordingly, he prays for bail. And a public prosecutor opposes the bail prayer. We have considered the materials on record. Petitioner had motive to commit the crime. The motive to commit the crime. He had illicit relationship. He had illicit relationship with one of the victims.
No, my lord. One of the doctor, my lord, co-accused.
And the victim is the brother-in-law who came to know about it.
Oh, petitioner had illicit relationship with the wife of one of the
Co-accused, my lord.
sisters. What is the relation? Like, who are the three people who died?
The petitioner is the sister-in-law of the male person who died. As my lord got it.
Right.
This petitioner had an affair with the court doctor.
Another person.
His brother-in-law came to know about it. Brother-in-law informed it to the husband.
So the father-in-law's family was.
His wife and his son were.
A petitioner had an illicit relationship with co-accused. His brother-in-law had objected to the relationship. As a result, she entered into a conspiracy with her. As a result, both the accused entered into a conspiracy and set fire in the house, resulting in the death of the brother-in-law and his family, that is, and his wife and minor child. In view of the grievous, heinous nature of crime, and we are not inclined to grant bail to him. To her. Next. Conspired to murder the brother-in-law and his family. Yes, next match.
Well, at page 32, co-accused have been granted bail by your lordships. I'm in custody for more than 3 years, 2 months.
No, he does stand with the same footing with the co-accused. Below, I would shoot your lordship.
Page 32, my lord.
I would like to see 53 and 54. My lord.
How long you are in custody?
Well, more than 3 years, 2 months, my lord. It's a term imprisonment matter, my lord.
Custody for more than 3 years. Vulnerable witness has been examined. There is no possibility of trial concluding in near future. Co-accused has been enlarged on bail. Accordingly, we are inclined to extend the same privilege to the petitioner.
2 petitioners, my lord.
Petitioners.
ACGM Barakpur.
Next.
108.
I became from the petitioner, my lord.
Why?
My lord, more than 3 years, my lord, I'm languishing behind the bar, my lord. 28 charge sheeted
Friday.
witnesses.
Friday.
As your lordship. Devada.
Next.
2-year, 1.
Friday, my lord. Case diary not received.
What is
395,
it?
397, my lord. 9 witnesses already
Most of the
examined.
witnesses are exonerated in nature.
No, no, no.
What?
9 witnesses has already been
Nine
examined.
witness. How many years you are in custody?
2-year, 1 month.
2 year, 1 month. That is
Two
your
of the
evidence.
two of the accused persons
No,
are
no, no,
identified in the court. They are covered with gamcha. Others are not identified. It came in the witness. My lord, 2 witnesses already examined. My lord, kindly see the witnesses, my lord.
Petitioners
My
are
lord,
in
page,
custody
my lord,
for
12.
2-year, 1 month.
petitioner is in custody for over 2 years. He prays for bail and a lawyer for the state submit. Trial is in progress. We have considered the materials on record. Petitioners were identified by witnesses.
No, my lord.
2 other co-accused.
2 other.
Because they are not
This
covered
has
with
not been
gamcha.
identified because
Otherwise, my lord,
recovery.
my lord, that is not came in the evidence, my lord. Maybe the CD is, my lord, is required.
CD is there. So some of the accused have been identified in court. Trial is in progress under such circumstances, and in view of nature of offense, we are not inclined to grant bail at this stage. Trial be expedited and concluded at an early date. Next.
113.
Now, see, there is a dispute. Lordship, I'm for the petitioner, my lord. There is a dispute regarding installation of Airtel Tower, my lord.
Airtel Tower.
My lord, 98
Find out
days
how many
custody.
cases is pending against him. Airtel Tower. How long you are in custody?
98 days custody. My lord, charge sheet is not submitted, my lord.
Huh?
That sheet not submitted.
Then why we will give him bail? Let him get bail before the statutory.
But I was inquiring from him whether he
Definitely
has.
charge sheet has been submitted.
No, 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 not submitted.
Miss Sinai, he may be implicated in other cases.
Oh, no. Me?
I have no instruction, my lord.
Who is he? From which
Investigating officer.
department?
CID.
ADG, CID. They are all investigating tower cases. So no other case he is implicated?
No, no, man. I have no instruction, man. I have no other case.
You will not have any instruction. Then why he has not submitted charge sheet? He is investigating.
Co-accused got bail, my lord. Other co-accused got bail.
Done it further.
Petitioner is in custody for 98 days. He submits police report has not been filed. In view of the aforesaid fact, petitioner is entitled to statutory bail. Petitioner shall be released on bail of 10,000 rupees.
PKM Hooghly.
Next.
PKM Hooghly. Head product.
Action. May it please, Your Lordship. My lord, allegations are under sections 302, 201, and 34. My lord, the petitioner is in custody for 1 year, 10 months. My lord, the allegation is that on the 20th of January 2023, the victim, Ramnath Maji, my lord, he left his house. Subsequently, his dead body, my lord, was recovered from a palm tree, my lord, by his cousin.
Rejected earlier on merits.
Yes, Lordship.
We are not inclined. What is the stage of the proceeding?
My lord, only whether, my lord,
Lordship, 4 witnesses have already
out of 25.
examined. No, all will not be examined.
Petitioner is in custody for over 2 years. He renews his bail prayer. Learned lawyer for the state submit. Trial is in progress. 4 witnesses have been examined. We have considered the materials on record. Bail prayer of petitioner was rejected earlier on merits. Full stop. Trial is in progress and 4 witnesses have been examined. Full stop. Under such circumstances, we are not inclined to grant bail to the petitioner. We direct the trial court to expedite the trial and conclude the same at an early date.
NDPS.
Rejected.
ফোন আছে? হ্যাঁ?
Lord, I am for the petitioner. Lord, the 307, 322 of the Indian Penal Code. Lord, 5 of the co-accused persons, Lord, they were granted bail by this honorable court. Lord, I am in custody, Lord, 140 days. Lord, I am standing on the same footing with those who are granted bail.
Co-accused are on bail.
Yes, my lord.
Petitioner is in custody for 144 days. Co-accused have been enlarged on bail. Petitioners, full stop. Petitioner stands on same footing with the said co-accused and is entitled to similar relief. ওই order থেকে bail conditions গুলো দিয়ে। Next.
I'm for the state lordship.
I'm for the petitioner, my lord. 307. Lastly, it was rejected by your lordship in the year 2023, July 2023. Now I am in custody 2 years, 7 months, 6 days.
Petitioner is in custody for more than 2 years. There is inordinate delay in trial. He renews his bail prayer. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Bail prayer of the petitioner was rejected on merits in July 2023. While rejecting the bail, this court directed the trial to be concluded preferably within 1 year. Full stop. Trial has not concluded as yet. Full stop. Under such circumstances, petitioner is entitled to bail on the score of delay in trial. Allowed 10,000 to share. Next.
My lord, I am for the petitioner. This is my renewal prayer, my lord.
170, but I will pray for 1 day. 7
Not today.
18 evidence has been annexed, my lord.
Go through it.
Lord, I am for the petitioner. If your lordship kindly turns to page 25 once.
Regular bail. You are just 44 days in
My lord,
custody.
50 days in custody. My lord was pleased to grant bail.
Who?
Yes, I'm showing that. Page 19 once and 25. Already 78% are on bail. And today your lordship was pleased to grant in item number 93 another
122 days.
My lord, if your lordship kindly comes to page 19 once. See the first paragraph.
All right. এটা ওই 118. Yours is 119.
118.
Last.
Same order as in
93.
93.
93.
হ্যাঁ শুধু হচ্ছে পিটিশনার ইজ ইন কাস্টাডি ফর 44 days, হ্যাঁ ওই 93 তে 122 days ছিল, ঠিক আছে, আর যা আছে তাই হয়।
Deeply obliged. Extremely.
Next.
More than 2 years in custody, my lord, and both the petitioners are on the same footing with 6 co-accused persons who have been granted bail by this court. My lord, page 25, 20, my lord, page 27, 29, and 31 are the bail order. Only yesterday, my lord my lords have granted bail to another 2 co-accused persons. Total 50 witnesses, only
page 31, lordship.
Petitioner is in custody for
more than 2 years, madam.
Huh?
Border same thing আছে 31 পেজটা দেখাও না।
হ্যাঁ দেখেন বলে দিচ্ছি।
The principal is already granted bail, already lordship has granted bail. Others are page 31.
Petitioner is in custody for
my lord, for more than 2 years, 6 days.
more than 2 years. He prays for bail on the ground of delay in trial. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Petitioner vulnerable witness has already been examined. Co-accused are on bail. There is no chance of trial concluding in near future. Under such circumstances, we are inclined to enlarge the
Great.
Kindly takes up this matter on 12th, because IO's examination is fixed on 11th this month.
This honorable
So kindly take up on 12th.
stated that the evidence should be completed within 2 months. Well, it was last rejected on 2nd of July 2024.
As per they deferred
the next date.
11.
11. Well, two months
12.
have elapsed, my lord.
12th. Fixed on 12th. Report be filed. Let the matter be fixed on 12th. Report with regard to the stage of the proceeding be filed on that day.
Here.
All right. I'm for the petitioner, my lord. But I'm in custody more than 74 days, my lord. Charge sheet filed. Neighbors.
The coordinate bench of this honorable court, the petitioner before your lordship.
They are neighbor, my lord.
And this coordinate bench of this honorable court had already rejected his anticipatory bail. The order sheet of this coordinate bench is on page 34, my lord. Yes. And the injury report at page 20. There is a head and chest injury.
Very good. How long you are in custody?
74 days.
Petitioner is in custody for 74 days. Investigation is complete. There is no chance of abscondence. Keeping in mind the aforesaid facts and the nature of accusation, we are inclined to grant bail.
Well, let him be outside the.
Yes. He'll stay at your residence. Cancellation. Adjourn this.
And I'm for the petitioner. And last occasion, this and it was directed to serve copy upon the opposite party, but it is endorsed that he has left. Your lordship kindly.
Nobody, service is not complete. Fresh notice be issued upon opposite party number 2 through registered speed post with acknowledgement due. Officer in charge.
Matra police station.
Matra police station shall also intimate opposite party number 2 with regard to pendency of the proceeding and next date of hearing. Matter will appear 4 weeks hence. Next. এই তোমার তো পারবে না অন্য কাউকে বলো।
My lord, I am for the petition. I am praying for adjournment, my lord.
Adjourn 2 weeks.
Grateful, lord.
I am for the statement.
So and so for state, nobody for petitioner. Adjourn 2 weeks.
For the petitioner, I am filing my reply.
Affidavit reply file. Nobody for opposite parties. State.
Yes, lordship.
So and so for
Led
state.
by Mr. Nodi.
Nobody for private opposite party accused. Adjourn 2 weeks.
Grateful.
I am for the state.
Lordship, I am for the petitioner, Lordship.
For state, nobody for petitioner. Adjourn 2
I am for
weeks.
the petitioner, Lordship.
Lordship, I am for the petition.
We have sharp copy, my lord, but no reply has been filed by the opposite
Who is
party.
appearing? So and so for petitioner, nobody for opposite parties, adjourn 2 weeks.
120, my lord, I am for the petitioner, my lord. We are filing.
130, Mr. Shantanu Debro is appearing for the state lordship. He has suffered heart attack.
We are filing a reply, my lord.
Praying for 2 weeks.
Petitioner files affidavit and reply. Learned lawyer for the state seeks accommodation, adjourn 4 weeks. 129, 130.
130, lordship.
But in 130, we are also filing
Same
reply.
order, same order, same
At a 130 reply.
One.
131. 130. আমাদের আছে 131. I am appealing for the either.
You are for?
I am appealing for the
Opposite party.
opposite party.
Mr. Mondal for opposite party accused.
I have filed opposition. I have already served.
Acha. Mr. Mondal appears for opposite party accused and files affidavit in opposition. Nobody appears for petitioner. Adjourn 2 weeks.
Opposition to file করলেন এখনটা ওই
My lord, I am appearing for the de facto complainant. My lord, earlier I have filed and served the.
My lord, I am for the state.
You are appearing for petitioner or what is de facto complaint? These are
Opposite party. I'm sorry.
How can it be opposite party? This is a cancellation of bail.
But I am for the petitioner in this one.
I'm sorry. I maybe apologize.
Yes.
But I am for the petitioner here. Mala I filed this cancellation because Mala there is a foul play with the court. What happened, Mala, initially they have filed a 438 application. Mala in that application, Mala the learned court Mala asked them to repay the money. Mala they enter into an agreement. Mala that agreement was given to the investigating agency. In the meantime, they have not pressed that application. After 1 year, my lord, they have filed another application, and my lord, that agreement was shown that we have made a compromise. In that way, my lord, the fraudulently, my lord, this
we have understood. Petitioner contends that the order, that the impugned order granting pre-arrest bail was procured through fraud. He submits opposite party number 2 had preferred an earlier application for anticipatory bail. The said application was disposed of.
It was not pressed.
In the said application, opposite party 2 entered into an understanding with the petitioner to repay the misappropriated sum. An agreement was executed by and between the parties, and the application was withdrawn. Subsequently, he filed another application and obtained anticipatory bail without honoring the said agreement. Learned lawyer for opposite party number 2 submits that what is your stance?
My lord, I have complied everything, my lord. 41 year has been complied.
About the money?
Money, my
agreement?
Lord, my lord, already, my lord, substantial money has been paid to him.
How much have you paid?
My lord,
Only 10 times has been paid. Thereafter, my lord, 83,334 each time. Now, the remaining amount of
some amount is due, my lord. Substantial amount has been paid, my lord.
So you pay the remainder.
Well, that is what.
But in this order, my lord, there is subject to correction, my lord, there is no reflecting to lordship kindly sees. Already, my lord, I cooperated with the investigation. 41A has been complied. It has been reflected in the impugn order.
How much is due?
3 lakh.
My lord,
এগ্রিমেন্টটা তো বলে দিচ্ছি
তুমি বলো না কত আছে বাকি?
আমি বলে দিচ্ছি total amount was 25 lakhs malad he entered into agreement paid malad I'm saying malad 10 malad installments he has given and the
How
rest
much is due?
about 15 lakhs about 15 lakhs
About 15 lakhs. All right. Opposite party number 2 submits that the dispute is civil in nature and he has cooperated with investigation. Almost a substantial sum of the amount due has already been repaid. Learned lawyer for the state produces, you have got case diary? Produces case diary. We have considered the tribal submissions at the bar. Full stop. It is settled law that an accused cannot, it is settled law that a direction to refund money cannot be incorporated as a condition to grant anticipatory bail. Be that as it may, breach of contractual obligations per se do not constitute offense of cheating. Admittedly, a substantial portion of the outstanding dues have been liquidated. Under such circumstances, we do not find any reason to cancel the order granting anticipatory bail. Application is disposed of.
Okay.
Yes.
एक निपटा भी गया. Yes, Mr. Ganguly.
So in this application, my lord, though
Madam, for the accused opposite party number 2 and 3.
Nobody appears for petitioner, so and so for opposite party number 2, 3, adjourn 2 weeks. 35.
I'm appearing on behalf of the petition.
I for the opposite party.
Your lord,
35 on
your
the
lordship,
statement.
lord granted anticipatory bail, lord.
Huh?
I'm mainly on the post bail conduct.
What did he do?
Threats are being held out to
All
withdraw
right.
the case, lordship.
Report be filed with regard to the grievances expressed by the petitioner.
I have lodged a specific complaint to that effect. It's at page
There's a
26.
direction to meet the investigating officer. I'm meeting.
Go on meeting. We are just asking you to
As
give
well
a
as it is.
report with regard to the complaint lodged. Complaint annexed at page 26 of the
yes.
petition.
Dated 31st of March 20.
Give a report. Adjourn 4 weeks.
Grateful.
Next. So and so for state, nobody for petitioner, adjourn 2 weeks. Two.
Sir, I'm for the private opposite party number 225.
For the petitioner in this matter.
Taking 2 weeks time to file reply, Malay affidavit reply. 2 weeks.
On the prayer of the petitioner, adjourn 2 weeks. Affidavit in opposition by opposite party number 225 is placed on record. ওটা আগে দাও, affidavit in opposition on record. আর তারপরে 2 weeks, reply be filed in the meantime. Next.
My lord, I'm appearing on behalf of the complainant. And the thing is that kindly I want to show you one order dated 17/9/2024.
You are for petitioner.
For the cancellation of bail, I want.
You are for petitioner. So and so appears for petitioner, nobody for opposite party, adjourn 2 weeks.
Lordship 139 and 140, Mr. Chattopadhyay is appearing for the petitioner, Your
Which
Lordship.
Chattopadhyay?
Mr. Uday Shankar Chattopadhyay.
Little Chattopadhyay.
Yes, Your Lordship.
Or
He's engaged in another courtroom, Your Lordship,
middle.
praying for a day's accommodation, Your Lordship.
On the prayer of the petitioner, adjourn 2 weeks. 39-40. বুঝতে পারছো?
39
Same
আর
order.
40 দুটো, yeah.
41. Nobody appears, adjourn 2 weeks. শোনো 41 থেকে 43 অবধি nobody appears, adjourn 2 weeks. আর 43 এর পর থেকে হবে। Sujoy,
Post bail conduct, my lord, I am praying.
where is the grievance?
My lord, page
Copy
29.
is served upon opposite
No,
party.
my lord, this first.
All right. Copy of the petition be served upon opposite party number
2, 3, 2, 3, 2 and 3.
2 and 3 to register speed post. And who is for 1?
No, the state.
And upon opposite party number 1 through public prosecutor, affidavit of service file, matter will appear 4 weeks hence.
I'm grateful.
Next,
I am for the state, my lord, this one.
nobody appears, adjourn 3 weeks.
Grateful.
Not today, my lord, miss the date, my lord.
Nobody appears, adjourn 3 weeks.
One photo, I am for the petitioner led by Mr. Joydeep বিশ্বাস, praying liberty to serve upon the opposite parties,
Who is the opposite party?
state and 2 and 3.
Who is the state? Which opposite party is the state?
Opposite and 1.
Where is
Opposite
your
par-
brief?
Don't have any.
So how do you know it is opposite party number 1?
1, my lord.
Copy of the application we served upon opposite party number 1 through public prosecutor
2 and 3.
2 and 3. Sure.
Sure.
2 and 3 to register speed post, file affidavit of service. Matter will appear 4 weeks hence.
Obliged, my lord.
Senior counsel Imtiaz Ahmed has left the court. paying
What?
Not to, Imtiaz Ahmed left the court.
Imtiaz Ahmed left the court, so we will have to rise. Huh? Adjourn 3 weeks.
May I just indicate one thing, my lord? I appear for the, my lord, opposite party, my lord. It hasn't not been served to
Who,
us.
where?
My lord, in the item 148. My lord, in fact, my lord, my
Give a copy. All right. After 3 weeks, you come. The senior is gone off.
Post bail conduct, my lord. For
Give
the
copy
first time.
first.
For the first time.
Copy of the petition be served upon opposite party through public prosecutor, opposite party number 1 and opposite party number 2 to
My lord, 2. দাঁড়া, দেখতে অত time নেই। মানে 6.
2 to 6 to register speed post, file affidavit of service, adjourn 4 weeks. 150.
I am for the petitioner, post bail conduct, my lord.
Are opposite party give us
Opposite party number 2 to 6.
Copy of the petition be served upon opposite party number 1 through public prosecutor and
2 to 6.
2 to 6 to register speed post with acknowledgement due, file affidavit of service, adjourn 4 weeks.
Right.
Next. Nobody appears, adjourn 3 weeks.
I'm for the petitioner, Lordship.
opposite party number 6 is the public prosecutor and
Right.
1 to 5 is the
Copy of the petition be served upon opposite party number 1 to 5 through registered speed post with acknowledgement due, and opposite party number 6 through public prosecutor, High Court, Calcutta. Affidavit of service be filed on the adjourned date, adjourned 4 weeks. Next,
My lord, I appear for the opposite party number 1 and 2.
you are for 1 and 2.
1 and 2. 3 is the state.
Nobody, you are for whom?
1 and 2.
Okay. Nobody appears for petitioner. So and so appears for opposite party number 1 and 2. Adjourned 3 weeks. Next,
So the copy has been no served.
so opposite party number 2 to
1 to 2 to 3.
2,
2 to 3.
2 to 3 or 2 and 3.
2 and 3.
Copy of the petition be served upon opposite party number 1 through public prosecutor and upon opposite party number 2 and 3 through registered speed post with acknowledgement due, file affidavit of service, adjourn 4 weeks. Dismiss, dismiss, not maintainable,
Well, violation of my
not maintainable.
violation of my lordship, being signed over by my lordship.
That is why we are saying not maintainable.
I am for the respondent number 2 and 3, my lord.
Yes,
Your
you don't,
lordship,
you
no,
will
my lord.
not, you will not be permitted to earn. Copy, serve copy. Copy of the application, you have already served.
I shall file opposition, my
Yes,
lord.
yes, definitely. File opposition. Affidavit in opposition be filed within 3 weeks. Reply 1 week thereafter. Matter will appear 4 weeks hence.
Deeply applaud.
I am appearing for the petitioner, your lordship.
Yes,
I am praying for not today, your lordship, as my
on the prayer of
is
the
not
petitioner,
present.
adjourn 3 weeks.
Your lordship, the affidavit of service.
That day.
Okay, sure.
Next,
My lord, 157, appearing for the petition led by Mr. Arun Kumar Maiti. The bail has been obtained on by misrepresentation.
all right, copy of the petition be served upon opposite party number 1 through public prosecutor. Opposite parties number 2,
2, 3, 4, 5.
2 to 5 through registered speed post with acknowledgement due. File affidavit of service. Matter will appear 4 weeks hence.
Grateful, man.
Next. Nobody appears, adjourn 4 weeks. Nobody appears, adjourn 4 weeks.
My lord, I am for the petition, my lord. 1 is the state and
All right, copy of the petition be served upon opposite party number 1 through public prosecutor and upon opposite party number 2 through registered speed post with acknowledgement due. Affidavit of service be filed on the adjourned date, adjourn 4 weeks.
My lord, I am for the petitioner. Opposite party number 1 is the state and grateful.
Nobody,
My lord, praying for
nobody appears, adjourn 4 weeks.
For the opposite party number 2
Malad
and
163, Malad, I beg to appear through VC, Malad. Malad, it's a cancellation of bail matter, Malad.
Adjourn 4 weeks.
My lord, I appear for the petitioner, my lord. Well, this is an application for cancellation, my lord. Petition is a de facto complainant. But there is a
You
violation
feel
of.
good if your bail application was, bail order was cancelled.
Ma,
Why
this-
you are filing now?
Well, this is.
Huh? All right, give a copy. Copy of the
My lord, I will
petition
serve a copy, my lord.
through public prosecutor, opposite party number 1 and opposite party number 2 through registered speed post with acknowledgement due. File
For
application.
conditions have been
Very
violated.
good. Next,
Grateful, my lord.
adjourn 4 weeks. 65,
4 weeks.
65, nobody appears, adjourn 4 weeks.
my lord, I am for the state, my lord. This is actually an application
So
of
that is bail, we have said. It will,
this is an application of anticipated bail.
it will appear, in the, let the matter appear in proper heading.
Obliged.
Other matters tomorrow.